in the military and paramilitary activities case. In that case, the court put in doubt the assertion of the United States that it was acting under Article 51 of the Charter in view of the absence of such notification. Thus, the existence of such notification, a contrario, shows such a conviction on the part of Russia. The speech of the President Putin was attached to the said notification and expressed the same legal basis for the special military operation. And I quote, "We simply have been left with no other way to defend Russia and our people than the one we are forced to use today. The circumstances require us to act decisively and immediately. The People's Republic of Donbas appealed to Russia for help. In this regard, in accordance with Article 51, Chapter 7 of the Charter of the United Nations, I have decided to conduct a special military operation with the approval of the Federation Council of Russia and pursuant to the treaties of friendship and mutual assistance with Donetsk People's Republic and the Lugansk People's Republic." The Genocide Convention was not referred to as a legal basis for the SMO. However, the speech gave a wider context of the situation, where genocide was mentioned, among other factors. Neither was the Convention invoked as a legal basis for the recognition of the DPR and LPR in the statement of the President of 21st February 2022. In providing an attachment to the notification under Article 51 that described the wider context of the situation, the Russian Federation did not depart from the practice of other notifications of the kind under Article 51 and did not diminish the fact that self-defense is the legal basis of the use of force. I will bring just some examples. In one case of such notification, 12 civilian casualties and 174 ceasefire violations have been reported. In another, Article 51 has been invoked in response to a plea from an exiled president for assistance against rebels who took power in armed coup d'etat while being supported by external forces seeking to project power over the country. Yet, on another occasion, the notification under Article 51 referred to bloodshed, agony, and the suffering of the people, which continue to grow after the regime has chosen to wage war against its own people. In the fourth case, circumstances regarding relocation of an extraterritorial site were described, related to treaties establishing borders. Numerous rather famous examples of Article 51 notifications, including those from states intervening in the present case, involve combating terrorism. Russia does not present comment on the veracity or legality of these notifications. However, these instances show how different considerations may color such invocations without necessarily implicating their legal basis. In Russia's case, Article 51 has been invoked after 8 years of attacks on Donbas by the Kiev regime, nearly 2 million of ceasefire violations, tens of thousands of artillery strikes by Ukrainian forces, more than 3,500 Donbas civilians killed, and over 10,000 wounded, including over 100 children killed by Ukrainian attacks. Madam President, another point that Ukraine wishes you to forget is the drastic escalation of hostilities in Donbas in February 2022. As Ukraine was getting increasingly more weapons from NATO countries, its military pressure against Donbas was escalating, and the situation in Ukraine became extremely volatile. Eager to stabilize it, in December 2021, Russia had approached NATO with proposal for a new security arrangement in Europe, which would ensure peace in Ukraine. However, these proposals were rejected by the USA and its European allies out of hand. Nevertheless, even faced with such grave security concerns and misgivings about the fate of Donbas, Russia did not act. Only in 2022, when Ukrainian forces escalated their armed attacks to an intolerable threshold, Russia recognized DPR and LPR's independence and together with them exercised the right to self-defense. This came after thousands of civilian deaths, nearly 2 million ceasefire violations. It's rising to more than 2,000 per day, and immense damage to Donbas civilian infrastructure, all in the name of Ukraine's bid to join NATO and become platform for that organization's forces hostile to the Russian Federation. In his speech of the 21st February 2022, President of the Russian Federation Vladimir Putin made the following statements. Ukraine's accession to NATO and subsequent deployment of NATO facilities has already been decided and is only a matter of time. We clearly understand that given this scenario, the level of military threats to Russia will increase dramatically several times over. In March 2021, a new military strategy was adopted by Ukraine. This document is almost entirely dedicated to confrontation with Russia and sets the goal of involving foreign states in a conflict with our country. The strategy stipulates the organization of what can be described as terrorist underground movement in the Russia's Crimea and in Donbas. It also sets out the contours of potential war, which should end, according to Kyiv strategists, with assistance of the international community on favorable terms for Ukraine, as well as, listen carefully please, with foreign military support in the geopolitical confrontation with the Russian Federation. With regard to the state of affairs in Donbas, we see that the ruling Kyiv elites never stop publicly making clear their unwillingness to comply with Minsk Agreement's package of measures to settle the conflict, and are not interested in peaceful settlement. On the contrary, they are trying to orchestrate a blitzkrieg in Donbas, as was the case in 2014 and in 2015. Not a single day goes by without Donbas communities coming under shelling attack. The recently formed large military forces make use of attack drones, heavy equipment, missiles, artillery, multiple rocket launchers, the killing of civilians, the blockade, the abuse of people, including children, women and elderly, continues unabated. There is no end in the sight. Russia has done everything to preserve Ukraine's territorial integrity. All these years it has persistently and passionately pushed for the implementation of the UN Security Council Resolution 2202 of February 17, 2015, which consolidated the Minsk package of measures of February 12, 2015, to settle the situation in Donbas. Everything was in vain. Ukrainian presidents and Rada deputies come and go, but deep down the aggressive, nationalistic regime that seized power in Kyiv remains unchanged. It is entirely a product of the 2014 coup and those who then embarked on the path of violence, bloodshed, lawlessness, did not recognize then and do not recognize now any solution to the Donbas issue other than a military one. In this regard, I consider it necessary to take a long overdue decision and to immediately recognize the independence of sovereignty of the Donetsk People's Republic and the Lugansk People's Republic. We want those who seized and continue to hold power in Kyiv to immediately stop hostilities. Thus, the principal concern was over devastating military campaign against Donbas, in spite of UN-approved peace accords and threat to the security of the Russian Federation. In this regard, let me recall what US Secretary of State Condoleezza Rice stated when recognizing the independence of Kosovo. We've been very clear that Kosovo is sui generis, and that is because of the circumstances out of which the breakup of Yugoslavia came. Special circumstances of the aggression of the Milosevic forces against Kosovars, particularly Albanian Kosovars, and it's a special circumstance. Of course, there is nothing unique about Kosovo. In 2008, Georgia attacked the breakaway republics of Abkhazia and South Ossetia in violation of the UN-approved regional peace arrangement. Likewise, in 2022, Ukraine escalated its attacks against Donbas republics in violation of the Minsk agreements. Both cases led to the recognition of the seceding states. The difference between these cases lies in the complete lack of the legal basis for NATO's armed attack against Kosovo, NATO's armed intervention in Kosovo, to which I will come in a moment. As you all know, the vast majority of the intervening states have recognized the independence of Kosovo. Ukraine did not heed any warnings and only escalated its strikes. On 24 February 2022, Russia, together with DPR and LPR, were forced to invoke Article 51 of the UN Charter. Madam President, distinguished judges of the court, this shows that Russia acted under Article 51 of the UN Charter. But this courtroom has only recently been full of people representing states who did not act under Article 51 when using force against sovereign state, under a pretext of alleged genocide that has never been confirmed. Madam President, another crucial point for the special military operation that Ukraine seeks to pass in silence is Ukraine's disdain to the Minsk agreements. Despite Kyiv's brutal assault on Donbass, since 2014, Russia has at that moment neither recognized DPR and LPR nor conducted military operation for their defense. For 8 long years, Russia has been hoping to implement Minsk agreements. The 2015 peace accord between Kyiv, Donetsk and Lugansk, endorsed by the Security Council and supported by France, Germany and Russia. These agreements only required Ukraine to grant autonomy to Donbass while preserving its territory. But Kyiv refused to do so, instead acting by force of arms. Last week, Russia's agent explained how Ukraine and its Western sponsors revealed that they never intended to fulfill the Minsk agreements. Kyiv has in effect rejected them by numerous and substantive violations. A list of them is available online and in the judges' folders. Ukraine rejected the implementation of the peace plan and never stopped striking Donbass. Madam President, members of the court, Ukraine also wished to strike out 8 years of war against Donbass. According to OHCHR report on Ukraine, during the conflict period from 2014 to 2022, OHCHR recorded a total of 3,107 conflict-related deaths, including 152 children. The number of injured civilians is estimated to exceed 7,000. The majority of civilian casualties took place in DPR and LPR. However, the real number of casualties is much higher, as not all of the killed or injured fell within the sight of international monitors. According to the authorities of the People's Republics, until 2022, more than 6,000 civilians were killed, and about 16,000 people, including more than 400 children, were injured on their territories. It was due to mass shellings of residential areas in Donbass by Ukrainian forces. In order to punish the people of Donbass, who refused to recognize the neo-Nazi regime, on the 14th of April 2014, Kyiv began a full-scale military operation. In May 2014, the right-wing radicals burned down around 46 civilians who called for the establishment of a federal system in Ukraine, in the building of trade unions in Odessa. Nobody has been punished for this crime. A few months later in this city, President Poroshenko made his infamous speech in which he promised that the people of the Donbass would have neither pensions nor salaries, and their children would sit in basements instead of going to school. On 14 July 2014, the Ukrainian forces shelled Mirny and Gaivo, micro-districts of Lugansk. As a result, at least 17 people were killed. On 1 August, Lugansk City Council reported 93 civilians had been killed and 407 injured between the 1st and 28th of July. There had been extensive damage to buildings, including schools, residences, factories and stores. A month later, Ukrainian Gramatsky TV published the story called Lugansk Under Siege. It showed Ukrainian Grad MLRS firing towards Lugansk from the outskirts of its suburb Veselaya Gora. On the same day, 11 people were killed in Snizhne, Donetsk region, as Ukrainian forces conducted an airstrike against residential area. On 27 July 2014, during a massive shelling of civilian residential area in the city of Gorlovka by the Ukrainian army, 22 people were killed. In total, in Gorlovka, 52 persons, including 9 children, were killed, 170 injured between 27 July 10 August 2014. Several times the Russian Federation has shown in this room a photo of trolleybus that was shredded by Ukrainian projectiles that fell in Donetsk in early morning on 22 January 2015. The OSCE SMM monitors confirmed that the deadly projectile was fired from Ukrainian forces' positions. The Ukrainian armed forces regularly attacked critical facilities, leaving the civilian population of Donbas without access to water, electricity, and sanitation. For example, the Donetsk filtering station, which supplied water to more than 300,000 people on both sides of contact line, had to suspend operations several times because of Ukrainian shelling. Ukraine also blocked attempts to fix the station, attacking station workers. For example, on 12 March 2018, near Yasinovataya, the Ukrainian military perforated a bus station full of workers with machine guns, wounding 5 of them. On 3 May 2018, the OSCE SMM chief monitor Apakan made a special statement that hundreds of ceasefire violations have been recorded on a daily basis by the SMM in the wider area surrounding the Donetsk filtration station, endangering lives and jeopardizing operation of the facility. Now look at these smiling faces. On this photo taken in 2019, President Poroshenko stands with Irina Gerashenko, an MP from Poroshenko's party. It was she who, as Ukraine's representative in the humanitarian subgroup of Trilateral Contact Group, part of implementation mechanism of Minsk agreements, regularly impeded its meetings, refusing to sit in the same room with representatives of Donetsk and Lugansk. This photo was published on the Facebook page. Now these two are staying in front of a damaged house in Avdiivka, together with an embarrassed local teacher whose students were hiding in the basement, and smiled. Ukrainian attackers gave no mercy to children. On the next slide, you can see the Alley of Angels in Donetsk. The names of the children killed by Ukrainian strikes are engraved on the granite slab. 4 of them were not even a year old. 10-month-old Sofia Danilkina was killed on 21 January this year as a US-made HIMARS missile fired by the Ukrainian forces hit her family's house in Kremenaya, LPR. On 14 March 2022, Ukraine hit the center of Donetsk using a .U missile with a cluster warhead, leaving 15 people dead. You see the consequences of this attack on the next slide. At least 5 children were killed on 8 April 2022 as Ukraine launched .U missile towards the railway station in Kramatorsk. The aim of this horrific attack was cynically simple: to intimidate civilians so they would keep away from any public transport and stay in the town. Thus, Ukrainian forces could use them as human shields. Kyiv propagandists, as always, groundedly blamed Russia for this attack, but they forgot the main thing. Russia withdrew .U missiles from service many years ago. 3 months later, on 5 July 2022, a 10-year-old girl was ripped in half in Donetsk by a NATO shell fired by Ukrainian forces. On the next day, President Zelensky said, and I quote, "Finally, it is felt that Western artillery, the weapons we receive from our partners, started working very powerfully. Its accuracy is exactly as needed." Many children were killed or wounded by Ukrainian mines. From the very beginning of SMO, the Ukrainian forces have been using MLRS cluster rockets to scatter Lepestok anti-personnel mines in the cities of Donbas. On the slide, you can see a 15-year-old boy wounded by such a mine. It is worth recalling that children's personal data were posted on the infamous Mirotvorets Peacemaker website, which is a shooting list of the Maidan regime. Over 350 minors are listed on this site without any impediments from Ukrainian authorities. On the slide, you can see the profile of 15-year-old Faina Savinkova, a young writer from Lugansk, who was listed on the site when she was 13. The portal administrators refused to remove her personal data, even after special warning from UNICEF. In our preliminary objections, we have mentioned that the Russian Federation was the country that hosted the largest number of Ukrainian refugees in the world. To be more precise, since February 2022, the Russian Federation received about 4.8 million residents of Ukraine and the Donbas republics, of whom more than 700,000 were children. The overwhelming majority of minors arrived together with their parents and other relatives. About 2,000 orphans were moved for the security reasons from orphanages in Donetsk and Lugansk and accommodated in children's institutions in Russian regions, far from the front line. These people choose Russia to be their shelter. Ukraine now dares to say the evacuation of children from this constant shelling and bombing were abductions. In their view, children should have been kept in the line of fire of the Ukrainian cannons. Since 2014, the Ukrainian army had widely used residential areas and social significant facilities in Donetsk and Lugansk regions to cover its troops and heavy weapons. At the same time, the Ukrainian forces intentionally used weapon systems from residential areas, aiming to provoke return fire and then blame Russia and DPR and LPR militia for the consequences. Thus, on the screen you can see a slide from OSCE SMM Deputy Chief Alexander Hug's briefing for the Diplomatic Corps of 1st June 2018, depicting a school building in Teple, Lugansk region, occupied by Ukrainian forces. You can also see students outside the school building. The Amnesty International report, the organization which has always been far from sympathizing with Russia, pointed out in its report of 4th August 2022 that, I quote, Ukrainian forces have put civilians in harm's way by establishing bases and operating weapon systems in populated residential areas, including in schools and hospitals. In February 2022, while the Russian Federation, in order to protect the civilian population and avoid needless losses, provided humanitarian corridors for the evacuation of civilians and foreign nationals in the Kyiv, Chernihiv, Sumy, Kharkov, Mariupol areas, on at least 26 occasions, the Ukrainian side always categorically refused to allow citizens to safely evacuate to the Russian territory. Madam President, members of the court, last Monday, Russia has shown you the Nazi roots of the Kyiv regime. Ukraine's agent had nothing to say to that except dismissing everything as lies. The reason is simple. Ukraine cannot argue against the plain historical truth. Here is another example. As Ukrainian President Poroshenko poses with his troops, a soldier boldly and prominently wears a large emblem of the 3rd SS Panzer Division Totenkopf, which was formed from the concentration camp guards and became notorious for brutality and war crimes, including mass killings of French and British prisoners. Poroshenko was the one under whose leadership Ukrainian troops devastated Donbas. Ukraine's agent had the audacity to quote this man as saying that it was Russia who attacked Donbas, not Ukraine. You have already seen the Donetsk Alley of Angels, memorials to children killed by Ukrainian strikes. Just these days, in Canadian Parliament, President Vladimir Zelensky, together with Canadian high-level officials, honored by a round of applause a person who served in notorious Nazi military unit during the World War II, SS Kalichina. Madam President, members of the court, in its presentation before this court, Ukraine attempts to conceal its fault for numerous hits on civilian objects and blames Russia instead. I shall begin with Ukraine agents blaming Russia for a missile attack on market in Konstantinovka on 6 September 2023. Evidence showed that the strike, which killed 17 civilians, including one child, was by Ukrainian anti-aircraft missile. Even Western media, such as New York Times, admitted that, but not Ukrainian agent. After this publication saw the light of day, Ukraine threatened the American journalists with criminal prosecution. Last Tuesday, Ukraine's agent, as well as one of Ukraine's counselors, once again mentioned the so-called Bucha massacre. However, that story is full of holes as any other coming from Kyiv. To begin with, Ukraine has still not provided any data on persons allegedly killed in Bucha. In September 2022, Russian Foreign Minister Sergei Lavrov has called on United Nations Secretary General Antonio Guterres to get the Ukrainian authorities to publish a list of people killed in Bucha. No reaction followed. No post-mortem examinations or even names of the deceased were provided. No relatives of the deceased have appeared in the public space. We do not know the basic results of the investigation. Ukraine is silent beyond the initial broad allegations. On 31st March 2022, when Mayor of Bucha, Anatoly Fedoruk, entered the town with Ukrainian forces, he recorded a congratulating video on the YouTube. In that video, there are no hints of any tragedy on the streets littered with corpses, only happy smiles and pleasant words. On 2nd April 2022, the National Police of Ukraine published video footage of Ukrainian forces entering Bucha. Again, no reference to any massacre is made. No dead bodies can be seen in this footage. Then suddenly, on 3rd April, a Ukrainian newspaper publishes an article about hundreds of murdered civilians allegedly discovered lying on the streets in Bucha. This information bomb then exploded all over Western media. Later, in September, an Italian journalist who was present at the scene in Bucha in the first days of April said in public statement that he saw Ukrainian military and civilians taking corpses out of trucks and laying them on the road in piles. Corpses which were tied with very clean bandages despite there having been heavy rains in Bucha for the 2 previous days. He also said that a volunteer informed him about corpses being taken from other locations to Bucha and then laid out for media to photograph. As with the other incidents, Kyiv was eager to shut down any questioning of the official narrative. In August 2022, the Kyiv City Prosecutor's Office brought charges of denial of the Russian armed aggression against a local resident of Irpin, Kyiv region. According to the case file, the accused woman denied the facts of murders and violence against civilians by the Russian military in her phone conversation with relatives. Irpin is located very close to Bucha. The two towns are separated only by the bridge blown up by the Ukrainian forces during their retreat, a photograph of which Mr. Gimli showed in this courtroom on 7th March. On Tuesday, Ukraine once more accused Russia of destroying the Kakhovka hydroelectric power plant, which resulted in flooding, the death of dozens of people, and an ecological disaster. However, facts again indicate that Ukraine is behind this crime. Perhaps the most brazen accusation of all was made by Ukraine's agent about Russia's alleged attack on Zaporozhye nuclear power plant. Russia has been in control of the plant since 1st March 2022, and it is Ukraine that has been shelling it and the neighboring town of Energodar for over a year. During discussions of these shelling incidents at the UN Security Council, not even Ukraine supporters accused Russia of attacking the plant its forces were controlling. The IAEA briefing Ukraine's agent cited had not named Russia as the attacker. Finally, Ukraine's agent voiced an incomprehensible allegation that by blockading Ukrainian ports, Russia has destroyed or held hostage millions of tons of grain, worsening global food shortages in Africa and beyond. Firstly, as you can see on the slide, it is the prosperous intervening states who were consuming the lion's share of the grain deal shippings, while African countries only received a tiny portion. Secondly, it is the sanctions imposed on Russia by the intervening states and their allies which block export of Russian grain that could feed those in need in Africa and Asia. Thirdly, It is Ukraine's continuous attack on Russia's Black Sea objects, including civilian infrastructure such as the Crimean Bridge, which necessitated measures against Ukraine's maritime facilities. Madam President, distinguished members of the Court, I have described the various ways in which Ukraine misled this Court. However, it is not alone in this practice. I will now turn to what the intervening states do not want you to hear. I'm, of course, talking about NATO states and their supporters who in 1999 attacked Yugoslavia, inflicting death and devastation upon that country in the name of stopping so-called genocide of Kosovars. Declared NATO's humanitarian intervention turned out to be a humanitarian catastrophe. On 31st May 1999, even before the end of NATO's bombing, the High Commissioner for Human Rights reported more than 1,200 civilians dead and about 4,500 injured as a result of the NATO bombing. NATO destroyed bridges, schools, hospitals, places of worship, making people seek shelter and separating children from their parents. NATO used cluster and graphite bombs in densely populated areas, putting civilian lives in enormous danger and leaving them without water and electricity. In another report, High Commissioner for Human Rights highlighted the following. In the NATO bombing of the Federal Republic of Yugoslavia, large number of civilians have incontestably been killed, civilian installations targeted on the basis that they are or could be of military application, and NATO remains the sole judge of what is or is not acceptable to bomb. NATO states had no reason to attack Yugoslavia in self-defense, nor have they invoked Article 51 to that effect. The Assad-style humanitarian intervention was performed under one pretext, stopping an alleged genocide in Kosovo. That, with all due respect, is not true. Last week, Mr. Koh went as far as saying, nobody stated there was a purpose to prevent genocide. That, with all due respect, is not true. Russia has already provided in its preliminary objections a long list of statements from high-ranking officials of NATO countries, claiming they were acting for that precise purpose. I will now remind the Court of these statements, as well as provide some new ones, including the ones belonging to Mr. Koh himself. The US President Bill Clinton had declared, "This was genocide in the heart of Europe. We must apply that lesson in Kosovo." NATO stopped deliberate systemic efforts at ethnic cleansing and genocide. The UK Prime Minister Tony Blair had declared, "We fought this conflict because we believed it was wrong to have ethnic cleansing and racial genocide here in Europe towards the end of the 20th century. The German Chancellor Gerhard Schröder stated, "The genocide in Yugoslavia cannot be met with pacifism." The Prime Minister of Spain, José María Aznar, said, "NATO must be on watch for any crisis in the world. I support the attacks. Ethnic cleansing, genocide cannot be the rules we live by." The Minister of Foreign Affairs of Poland told the General Assembly, "We have to come to accept that absolute sovereignty and total non-interference are no longer tenable. There could be no sovereign right to ethnic cleansing and genocide." Almost every intervener in the present case supported NATO's bombing of Yugoslavia under the pretext of so-called humanitarian intervention aimed at preventing genocide and ethnic cleansing. The intervening NATO countries did not hesitate to openly reveal the purpose of the NATO's attack on Yugoslavia before this court back in 2004. In particular, Germany plainly declared that it is a matter of common knowledge that the military operations against Yugoslavia were undertaken in an attempt to rescue Kosovo Albans from being subjected to atrocity, including genocidal acts. Italy also openly admitted before this court that NATO's purpose was preventing genocide. And I quote, "The Atlantic Alliance was compelled to intervene to prevent an ongoing genocide. A group of states have felt compelled to intervene against a state to halt genocide." To make another example, Canada made the following statement: "Genocide is the gravest of international crimes. Canada's participation in the NATO air operation was prompted by a pattern of events in Kosovo that has shocked the conscience of the world." Even those interveners who were not NATO member states still supported the bombing campaign under the pretext of preventing genocide. Poland's Prime Minister Buzek, voicing support for NATO bombings, had stated, "There is no question that what is going on in Kosovo is genocide." I now come to the past statements of Ukraine's Counsel, Mr. Harald Kohl. On 24 April 1999, 1 month into NATO's bombing campaign against Yugoslavia, Mr. Kohl, in his capacity as US Assistant Secretary of State, speaking before the UN Commission on Human Rights in Geneva, stated the following: "It is impossible for me to introduce my country's resolution on human rights situation in the former Yugoslavia without referring to the catastrophic human rights violations taking place in Kosovo. We are witnessing a mass human rights epidemic that includes war crimes, crimes against humanity, grave breaches of international law, and indicators of genocide." It was not a single instance. Mr. Kohl repeated his allegations of genocide at various forums. On 16 April 1999, he had spoken at The Hague, saying that, "As we speak, the region-wide killing, raping, shelling, burning, deportations continue in Kosovo. In the Balkans in the 1990s, we have similarly witnessed the rise of ethnic cleansing, a massive human rights violation, and that includes war crimes, crimes against humanity, and acts of genocide." On 18 April 1999, he reiterated his claim in Skopje. "We are witnessing a mass human rights epidemic that includes war crimes, crimes against humanity, grave breaches, and acts of genocide." Neither were these statements purely humanitarian in nature. On the contrary, Mr. Kohl had used allegations of genocide to directly promote NATO's military intervention in Yugoslavia. And I quote, "Such a massive human rights crisis demands immediate and major human rights response. 50 years after Nuremberg, our only choice cannot be to sit back, watch ethnic cleansing occur, and only then seek accountability after the act. The United States, the Netherlands, and their NATO allies exhausted all diplomatic avenues before finally turning to force, backed by diplomacy, justified by international law and humanitarian necessity. We must continue this course until these victims can return to their homes in freedom." As you can see, contrary to what Ukraine says, NATO had acted under the pretext of preventing genocide. Moreover, Ukraine itself had slammed Belgrade actions in Kosovo and said that its refusal to implement relevant Security Council resolutions led to the use of force by NATO. And I quote, "Belgrade's refusal to sign these agreements formulated by the contact group had resulted in the breakdown of negotiations. Therefore, the provisions of the relevant Security Council resolutions had not been fully implemented and had led to the use of force." Ukraine also stated that a peaceful political settlement was possible on the basis of granting a wider autonomy to Kosovo. In an astounding volte-face, Ukraine then refused to implement the Security Council Resolution 2202, endorsing the Minsk agreements, which stipulated the granting of autonomy to Donbas, and instead chose to aggressively attack DPR and LPR, thus leading to the use of force by Russia. Madam President, members of the Court, now I will address contributions of intervening states in this process. The intervening states have shown that they possess no genuine interest in interpretation of the Genocide Convention, but are instead guided by purely political expediency and act in direct contradiction to their previous legal positions expressed before this court. The common cause between Ukraine and the interveners is so obvious that restating it would be almost right. They make no secret of it, instead brandishing various joint declarations and open admissions of close cooperation. Despite their self-professed interest in interpreting the Genocide Convention, they have never chosen to intervene before in cases related to it, even when actual allegations of genocide were at stake. Russia has already drawn the Court's attention to the joint statement of 20 May and 13 July of 2022, signed virtually by each intervener. Ukraine's allies explicitly state that they, I quote, welcome Ukraine's application against Russia and joint intention to explore all options to support Ukraine in its effort before the ICJ. This common purpose was so apparent at the oral hearings there is no need to give examples, except perhaps of one of the most extreme. Latvia went as far as directly quoting the speech of Ukraine's Consul, Monsieur Tuvinan, while restating support for his views no less than 3 times in a row. No better illustration of total lack of original interpretation or interest can be provided, except perhaps this collective photo of the interveners together with Ukraine's legal team. The representative of France openly underlined close coordination efforts provided by all the member states of the European Union in this regard. However, the interveners go well beyond common purpose. Their interventions also betray commonality of substance, often literal, with parts being identical to the letter. You can appreciate some glaring examples of such plagiarism on the slide. These suspicious similarities have not gone unnoticed in the international juridical community. A group of international lawyers have published recently a research report dissecting these interventions and have come to a rather obvious conclusion, and I quote, "Whether the stark similarities between the argumentation of many of the intervening states flows from a non-paper circulated among the states, or simply some states follow the lead of others, cannot currently be verified. However, our findings seem to suggest a somewhat sheep-like behavior pattern of many intervening states by uniformly adopting arguments from elsewhere." Another example of the interveners' hypocrisy is Germany, which addressed Russia's admissibility objection contained in a document in which Germany did not or should not have had access to. Further, the metadata shows that France, Portugal, the United Kingdom used the same author to prepare their observations. However, even when the court urged the states to group their submissions to preserve good administration of justice, most of these countries refused to make joint statements. The reason is clear. The interventions in this case are not used to genuinely interpret the convention. They represent an attempt to hypnotize the court by pronouncing Ukraine's position as many times as possible, or to put pressure on the court by presenting an appearance of overwhelming support of its position. Madam President, but the far more egregious example of intervening states' duplicity is the plain contradiction of their current claims with their own legal positions, as expressed in the legality of the use of force cases. As Russia has shown before, the NATO states had openly stated that they attacked Yugoslavia under the pretext of preventing genocide. This was done not only by their leaders on the political plane, but also by their representatives in this court. To list just a few examples, Italy contended before this court. It is accordingly clear that Atlantic Alliance was compelled to intervene to prevent an ongoing genocide. A group of states who, much against their will, have felt compelled to intervene against a state to halt genocide. Germany, in turn, stated before this court, it is a matter of common knowledge that the military operations against Yugoslavia were undertaken in an attempt to rescue the Kosovo Albanians from being subjected to genocidal acts. More than that, intervening states have previously held drastically different position on the interpretation of Article 9 of the Genocide Convention and its cooperatione materia. Now the NATO states have drastically shifted their position regarding aforementioned issues. On this topic, in 1999, Germany had stated in its preliminary objections, Article 9 of the Genocide Convention could provide the only basis for jurisdiction. However, given the absolute lack of information regarding the subjective ingredient of the crime of genocide, that clause is simply inapplicable. There can be no question of a dispute relating to the interpretation, application, or fulfillment of the Convention. Germany went on criticizing Yugoslavia case against it. Even a short glance at Yugoslavia's memorial reveals instantly that Article 9 is referred to in a last-ditch effort to find a basis for submitting the case to the court. The bulk of the dispute lies outside the confines of the Genocide Convention. As far as, in particular, the principle of non-use of force, the principle of non-intervention, and the duty not to harm the environment are concerned, the jurisdiction of the court has never been established either in the Charter or in treaties and conventions in force. Now, however, Germany espouses a diametrically opposite view. And I quote, Article 9 of the Genocide Convention also covers disputes in which one state party of the convention alleges that another state party is committing acts of genocide, and where, relying on such accusations, the former state party then takes action in the form of using military force against the latter. In another example, in 1999, France argued, the court is without jurisdiction to rule on the issues concerning alleged violations of United Nations Charter and certain principles and rules of international humanitarian law applicable in armed conflict, as those issues do not fall within the provisions of Article 9 of the 1984 Genocide Convention. But now France claims the exact opposite. Indeed, since Article 9 sets forth that the court may be seized of all disputes relating to the present convention, the fact that certain acts or omissions at the origin of the dispute may be subject to different legal qualifications, which may fall within the scope of instruments other than 1948 Convention, has no bearing on the application of this provision. France repeated this during the oral hearings. Disputes involving improper allegations of genocide or relating to improper use of the obligation to prevent and punish genocide therefore fall within the scope of the provisions of the Genocide Convention and consequently within the scope of the consent provided for in Article 9 thereof. Is that to be considered a genuine position by the intervening state? The Russian Federation does not believe so. Given that under this approach France or any other intervener may do another U-turn on its interpretation of the Genocide Convention once it would benefit them. It becomes even more evident when we observe France blaming Russia for its special military operation in Ukraine and at the same time supporting military intervention in Niger. To take yet another example in the legality of the use of force case, the United Kingdom asserted the following. Jurisdiction under Article 9 would not extend to disputes regarding alleged violation of other rules of international law, such as provisions of the United Nations Charter relating to the use of force and the Geneva Conventions and additional protocols of 1997 relating to the conduct of armed conflict. At the same time, in its written observations, the United Kingdom claims Article 9 of the Genocide Convention confers upon the court jurisdiction ratione materia to determine the extent to which Article 1 allows or requires a contracting party to engage in certain conduct that might otherwise be unlawful under international law. The United Kingdom was especially brazen in its oral assertion. The scope of other rules of international law that constrain conduct permitted by Article 1 is not indefinite. This is not the case for the constraints within Article 1. It is unthinkable that a state fulfilling its undertaking to prevent genocide in good faith could do so through aggression or other international crimes. And yet, it was the United Kingdom which, along with other NATO states, committed aggression against Yugoslavia under false pretext of genocide in Kosovo. It is clear. To align their position with the one of Ukraine, the interveners now have to claim the exact opposite of what they claimed some 25 years ago. But it is not the content of the Genocide Convention that changed over the past quarter of century. It is the political motivation of Ukraine's allies. However, with such change of position, they risk nothing. I would like to finish this part of my speech with another extremely pertinent quote from Germany's preliminary objections. Article 9 must not denigrate into a weapon for the purpose of frivolously discrediting an adversary. The jurisdictional requirement of Article 36 have precisely as one of the main objectives to protect a respondent from utterly baseless claims. Whether they are fulfilled must therefore be considered with the utmost care. This is necessary, in particular, with the view to shielding the authority of the Genocide Convention from being abused in instances where any other attempts to find foundation of the court's jurisdiction has failed. I can only hope the court follow this astute approach. Madam President, esteemed judges of the court, the only conclusion, then, can be drawn from the interventions is that they are not genuine, contravene the interveners' prior positions taken before this court, and amount to abuse of process. In this context, I would like to draw your attention to the document which has been adopted 2 days ago at the United Nations, the political declaration of the 4th ministerial meeting of the Group of Friends of the Defense of the Charter of the United Nations and undersigned by 18 states. This declaration includes the following appeal. We reaffirm the principle of peaceful settlement of disputes and express our firm conviction that states shall resolve their disputes through the dispute settlement mechanisms that they have agreed upon, and underlined that all means of settlement of disputes should be used in good faith and in the spirit of cooperation in order to resolve the goal of resolving disputes in a peaceful manner, in accordance with applicable international law, and thus leading to de-escalation of tensions and the promotion of friendly relations and cooperation among states. In accordance with the Charter of the United Nations, in this regard, we stress the importance of safeguarding the credibility and independence of the principal judicial body of the United Nations, as established by the Charter of the United Nations, and caution against the misuse of Article 63 of the ICJ statute. This is what we are facing now, a blatant misuse of the right to intervene and of the Genocide Convention by the very states which have previously used genocide as a pretext in order to launch the attack on a sovereign state, all the while claiming that the court has no jurisdiction to entertain claims under the Genocide Convention regulating their use of force. But now, when they need to support their client Ukraine, and the only way to do that is claim the opposite of their previous legal views, they do so without shred of hesitation. Such inconsistent statements and hypocritical attitudes of the intervening states should have no effect on the interpretation of the Genocide Convention. It is plain that these statements are made for purely political purposes and should not be given any legal value or force in the interpretation of the Genocide Convention. If anything, the actual legal position of the states before this court in cases concerning themselves should be taken as the real reflection of their understanding of the Genocide Convention. The interpretation of a document so crucial as Genocide Convention should not be bent at will to serve political goals of one group of states. Madam President, members of the court, I will not touch upon the countless flaws of Ukraine's legal position. Our Council will deal with them shortly. But I will emphasize key points. If Ukraine's views were to be accepted by the court, it would be the first time when the court would ascribe a legal basis for the use of force or recognition of states to a state that took these actions, and it would be done explicitly against its will. It would also overturn the entire international legal system with regard to critical rules bearing the nature of jus cogens, the right of self-defense and the right to self-determination of peoples. Following Ukraine's logic, any action in self-defense or recognition of states would fall under the court's jurisdiction whenever their invocation is even remotely linked, including only on political plane, to subject matter of a treaty with a compromissory clause, be it anti-terrorism, racial discrimination, genocide, or any other topic. Any such remote link would, according to Ukraine, potentially engage the court's jurisdiction regarding states' responsibility in respect of both the treaty and the jus cogens norm. Needless to say, that would be completely contrary to the fundamental principle of voluntary jurisdiction and will severely upset the realm of international law. Madam President, esteemed members of the court, I will now introduce the advocates who will present this and other arguments in more detail. Professor Hadi Azari will explain further Russia's first preliminary objection, namely that there is no dispute between Ukraine and Russia under the Genocide Convention. Professor Alfredo Crossato Neumann will continue with the second objection on the lack of the court's jurisdiction ratione materia. Professor Singho E will go on with Russia's third objection on the inadmissibility of new claims and the fourth objection on the lack of a fair utile. Mr. Kyrylo Dovichenko will further demonstrate Russia's fifth objection, that Ukraine's claims seeking a reverse compliance declaration are inadmissible and that Ukraine's claim constitute an abuse of process. He will also briefly comment on the matter of the order on provisional measures, which is not appropriate for the discussion at the present stage. Finally, Monsieur Jean-Charles Chikayar will give a presentation on the issue of Article 9 and will address some of the points made by the interveners. I thank you, Madam President, and honourable members of the Court for your attention. I now kindly ask you, Madam, to invite Professor Hadi Azari to address the Court, unless you would like to announce a coffee break.
I thank the agent of the Russian Federation, and I invite Professor Hadi Azari to take the floor. You have the floor, Professor.
Merci beaucoup, Madame la Présidente.
Thank you, Madam President. Madam President, distinguished members of the Court, in my oral presentation on last Monday, I had explained why no dispute existed between the parties under the 1948 Genocide Convention, which should therefore bring the Court to decline its jurisdiction to entertain Ukraine's claims. Ukraine's counsel contended on Tuesday that Russia was wrong both from a legal and factual standpoint, which this is not the case. As to the law, Russia's legal position relies on the Court's established jurisprudence, and Russia is not requesting the Court to change its approach, but in fact to confirm it and to apply it to this case. As to the facts, Ukraine's position does not meet the standards set by the Court. I will address these 2 points successively. On Monday, I emphasized that according to the Court's established jurisprudence, in order to conclude that a dispute exists, the Court must establish, based on evidence presented to it by both parties, that on the date on which the application was filed, the respondent, or rather the applicant, positively opposed the respondent positively opposed the applicant's claim. I have concluded that Ukraine's application must be dismissed because Ukraine has not proved that before filing its application it had claimed a breach of the 1948 Convention and that its claim was positively opposed by the Russian Federation. Ukraine's counsel did not engage in this discussion. Counsel did not demonstrate the opposite. She merely claimed that the approach was erroneous and that Russia is attempting to impose novel requirements that have already been dismissed by the Court. I shall demonstrate today that far from being novel requirements, Russia's approach is firmly entrenched in the Court's jurisdiction, and therefore there is no valid reason for departing from it in the present case. Distinguished members of the Court, the Court has detailed the test for the existence of a dispute in the Georgia versus Russian Federation case as follows. The Court now turns to the evidence submitted to it by the parties to determine whether it demonstrates, as Georgia contends, that at the time it filed its application and with respect to the interpretation of application of cert, it needs to determine whether Georgia made such a claim and whether the Russian Federation positively opposed it, with the result that there is a dispute between them in terms of Article 22 of cert. End of quote. The Court examined this evidence in the light of this test, including through letters, statements and acts of Parliament and other documents that Georgia had introduced. The Court had dismissed everything that did not include a claim or a reproach or an accusation or an allegation made by Georgia against Russia. However, In order to establish the existence of a dispute, the court only used evidence that contained the claims made by Georgia against Russia, and only for this reason. The court concluded, and it appears on your screen, the court observes that while the Georgian claims of 9th to 12th August 2008 were primarily claims about the allegedly unlawful use of force, they also expressly referred to alleged ethnic cleansing by Russian forces. These claims were made against the Russian Federation directly and not against one or other of the parties to the earlier conflicts, and were rejected by the Russian Federation. The court concludes that there was a dispute between Georgia and the Russian Federations about the latter's compliance with its obligations under cert as invoked by Georgia in this case. End of quote. The Georgia versus Russia case has made case law, indeed. President Awada, Judges Seema Abraham, Donahue, and Judge Ad hoc Gaillard have observed in their joint opinion attached to this decision that it appears from the grounds retained by the court that a dispute only exists if, before filing the application, the applicant has notified the respondent of its claims and if the respondent has positively opposed these claims. The fact remains that the said jurisprudence has been followed to this day in other cases as well. For example, in Belgium versus Senegal, the court concluded that there was no dispute between the parties after having found that the documents relied on by Belgium did not clearly indicate what conduct it accused the respondent of. This is the conclusion of the court on the screen, and I will only read the relevant parts that are highlighted. Neither document stated or implied that Senegal had an obligation under international law to exercise its jurisdiction over those crimes if it did not extradite Mr. Habré. In the light of the diplomatic exchanges between the parties reviewed above, the court considers that such a dispute did not exist on that date. As I mentioned last week, it is this requirement that the applicant must meet to make its claim against the respondent that led the court to specify in the Marshall Islands case that the applicant must demonstrate, and I quote, that the respondent was aware or could not have been unaware that its views were positively opposed by the applicant. End of quote. In the same instance, by applying the test to the declaration relied on by the applicant, the court concluded that there was no dispute between the parties. Indeed, the court held that this statement invoked by Marshall Islands, and I quote, the statement is formulated in hortatory terms and cannot be understood as an allegation that the United Kingdom or any other nuclear power was in breach of any of its legal obligations. It does not mention the obligation to negotiate, nor does it say that the nuclear weapon states are failing to meet their obligations in this regard. End of quote. The court also dismissed the second statement relied on by the applicant because it said that it does not specify the conduct of the United Kingdom that gave rise to the alleged breach. The focus or the emphasis on the respondent's allegedly unlawful conduct. The lack of clarification and identification of this conduct is what led to the Marshall Islands application being rejected. The court has applied the same test to the claims made by Nicaragua in the case of the alleged violation of sovereign rights and maritime spaces in the Caribbean Sea. The court ruled that a dispute between the parties existed because, and as long as, and I quote, Colombia was aware that its enactment of Decree 1946 and its conduct in the maritime areas were positively opposed by Nicaragua. End of quote. The court cannot have been any clearer. These cases show that for the International High Court, a dispute exists if, and only if, the applicant is able to prove that it had accused its opponent of allegedly unlawful conduct, and if the opponent had positively opposed this claim. Furthermore, it needs to show that the respondent was aware that its views were positively opposed by the applicant. This is how a legal dispute crystallizes and becomes justiciable. Ukraine and the intervening states relied heavily on the Gambia versus Myanmar case. They would not have done so had they read it more attentively. In this case, the court did not depart from its jurisprudence that I just described. Two statements by Gambia were in question. The statement from September 2018 and the statement from September 2019. Both involved reports made by the fact-finding mission of the UN Security Council. The 2018 statement or report, I'm using the court's wordings, contained specific allegations on the perpetration of crimes in the Rakhine State whose nature, seriousness and magnitude was similar to the crimes that had enabled the establishment of genocidal intent in other contexts. However, the 2019 statement expressly referred to Myanmar's responsibility under the Genocide Convention. And the court held that, and I quote, Myanmar's rejection of the findings of these reports demonstrates that it was positively opposed to any allegations of genocide being committed by its security forces against the Rohingya communities in Myanmar, as well as to the allegations of its responsibility under the Genocide Convention for carrying out acts of genocide. Such allegations were contained in the two reports and publicly taken up by the Gambia. End of quote. Therefore, Myanmar, the respondent, was clearly aware that its conduct, that is to say the treatment of the Rohingya group, was what the applicant was holding against it, and that it was accused of having violated the Genocide Convention and could thus be brought before the court. Even if the convention has not expressly been mentioned in the statements made to the UN General Assembly, the parties debated the question of the state's responsibilities for committing genocide. They did so in the light of the conclusions of the reports of the fact-finding mission containing specific references to the Genocide Convention. Whether Ukraine and the intervening states like it or not, in Gambia versus Myanmar, there was indeed an allegation made against the respondent, which was positively opposed by the respondent. Two elements sine qua non, therefore, of the existence of a dispute, both of which are absent in the present case. Distinguished members of the court, you had made it clear the court does not accept surprise introductions in this case. The applicant must formulate legal claims against the respondent before filing its application so that the respondent is made aware of what its alleged unlawful behavior is and to act accordingly. Ukraine and the intervening states repeated constantly that the concept of a dispute is vast, and this doesn't help Ukraine, quite the opposite. The court, in this manner, would not have demanded compliance with so many rules for a dispute to exist, and it would not have dismissed so many applications and requests submitted to it in the past due to the breach by applicants of such requirements. The claim that the existence of a dispute is a question of merits and not form or procedure, often mentioned by Ukraine and certain intervening states, does not indicate that the applicant is free to comply with these requirements or not. It only means that it is free to choose the means to make its claim against the opponent and to manifest its opposition to the respondent's conduct. Madam President, I now come to the second part of my presentation relating to the facts of this case. If you wish, Madam President, we can break at this point, or I can continue, if you so desire.
For raising the question, let's continue for another 15 or 20 minutes. When you get to a suitable point in 15 or 20 minutes, please let me know and we can take a break then. Thank you.
Ukraine intends to base the court's jurisdiction on Article 9 of the 1948 Convention. Therefore, to establish its dispute, Ukraine must demonstrate, 1, that it has claimed that Russia has breached the 1948 Convention through allegedly unlawful conduct, 2, that its claim was positively opposed by the Russian Federation, and 3, that the disagreement between the parties existed on the date on which the application was filed. As I explained last week, Ukraine has failed to meet these conditions. Its counsel did not contend the contrary last Tuesday either. The assertion by one party that a dispute exists is not the factor that determines if indeed the dispute exists or not. It is for the court to decide this by taking into account, in particular, any statements or documents exchanged between the parties. The fact is that in this case, there is no trace of any statements or documents exchanged between the parties that relate to the alleged dispute presented to the court. Even though Ukraine has communicated extensively with the Russian Federation on measures on numerous issues between 2014 and 2022, it has never made any reference to the Genocide Convention or its object, either in diplomatic correspondence or in any other way that would have enabled the Russian Federation to be made aware of its position. Being aware of the weakness of Ukraine's position, some intervening states attempted to defend Ukraine's inaction. The United Kingdom contended that the court had expressly recognized that a dispute can exist even in the absence of diplomatic exchanges. End of quote. However, this observation applies to situations where there is no communication between the parties. Naturally, the absence of such communication should not prevent the court from being seized. However, this logic cannot apply to a situation where the parties have been in communication actively since many years, but no reference has ever been made to the alleged subject matter of the dispute by the applicants in its communications.
Madam President, might I repeat that between 2014 and 2022, Ukraine and the Russian Federation exchanged an extensive diplomatic correspondence, both long and continuous. Their representatives met on numerous occasions in various settings, both bilaterally and multilaterally. Yet, Ukraine did not once refer to the Genocide Convention or its object. Ukraine sent hundreds of diplomatic documents to the Russian Federation on a number of issues, but not one relating to the Genocide Convention or its object. Distinguished members of the court, as I pointed out last week, Ukraine has been at pains to convince you that the dispute did nevertheless exist on the date of the filing of the application, since Russia had accused Ukraine of having committed genocide, and that Ukraine had challenged Russia's claim. However, Ukraine's attempt to... This is a matter pertaining to Russia, not Ukraine. However, Ukraine's attempt to reverse the test for the existence of the dispute is bound to fail. The court itself will, of course, ensure consistency with its jurisprudence. However, I shall demonstrate that even if one were to apply this reverse test, Ukraine's line of argument is entirely unfounded. Regarding the declarations made by Russian politicians, which contained the term genocide, one can but admit that a simple use of this term does not suffice to establish the existence of a dispute under the Genocide Convention. Last Monday, I quoted an article by William Shabas to support my claim that a distinction must be made between the use of the term genocide for rhetorical purposes or political purposes and an invocation of the 1948 Convention. It might be worth mentioning that at the very moment that Ukraine was denouncing this assertion in this room, President Zelensky was accusing Russia of committing genocide in his statement to the UN General Assembly. Other examples, and you will see some on the screen, show how frequently politicians utter this word. Cuban and Mexican leaders characterized the American embargo on Cuba as genocide. In 2023, Kenya's president characterized the situation in Sudan as genocide. Hugo Chavez, the president of Venezuela, used the word genocide in various statements he addressed to President Bush and to Israel. Examples abound. Needless to go through them all here. Council for Ukraine spent much time discussing Russia's investigative committee. The investigative committee is an independent body tasked, as is clear from its title, tasked with carrying out individual criminal investigations. And even assuming these investigations were to lead to a genocide allegation, the file would then be sent to a competent tribunal, the only one in a position to determine the soundness of a potential genocide allegation. The jurisdictional immunities case, referred to by several speakers, has no bearing whatever on the instant case. This case dealt with final judicial decisions, which clearly may and must be understood as an act of the state, unlike the committee's statements made during an investigation launched under the Russian Criminal Code. Here, yet again, they do not pertain to state responsibility for genocide, but to individual criminal responsibility. An investigation into the conduct of a person, which can lead to the case being closed for lack of evidence or because the court has been seized of the case, can under no circumstances point to the existence of a dispute between states. Ukraine's attempt to depict the investigation committee as a body representing Russia internationally must equally fail. First and foremost, because the law is unambiguous, the investigative committee clearly does not have such powers and duties. A body which does not represent the views of a state internationally cannot give rise to a dispute between states. Ukraine has indicated that the investigative committee has represented Russia at the international level, attending, for example, formal bilateral negotiations between Ukraine and Russia. However, in its sides, Ukraine has hidden the fact that the delegation was led by the Foreign Affairs Ministry, which is the body in charge of representing Russia at an international level, and that members of the committee had attended as experts on matters relating to mutual legal assistance, as you can see here on the screen. Besides, the two delegations met to discuss the ICSFT, which is clearly a criminal law convention covering individual criminal responsibility for acts of terrorism financing. In its judgment, the court, in its ruling on preliminary rejections in the ICSFT and CRD case, the court, as I said, has clearly stated that this convention did not cover what is called state terrorism or the financing of state terrorism. According to Ukraine's contentions regarding a purported prosecution by the Investigative Committee on Ukraine's international responsibility for genocide is entirely meaningless. As to Russia's reference to the ILC's articles on state responsibility, Ukraine and various intervening states have argued that Article 43 of the ILC draft articles on state responsibility, according to the draft's commentary, does not cover matters relating to jurisdiction or to the admissibility of a case. Ukraine and the states have misconstrued Russia's position. Russia did not raise this argument as an objection to the court's jurisdiction or to the admissibility of Ukraine's application, but rather as the proof of the absence of a dispute between the parties. In other words, it was invoked with a view to explaining that even if the word genocide was uttered by various Russian authorities, it was not an accusation made with reference to the convention. The answer explains, and it is right, that, and I quote, there is in general no requirement that a state which wishes to protest against a breach of international law by another state or remind it of its international responsibilities in respect of a treaty or other obligation by which they are both bound should establish any specific title or interest to do so. End of quotation. Ukraine's Council has described the committee's work as 8 years spent on preparing a false justification for Russia's special military operation. Yet she did not explain why Ukraine had waited 8 years to seize the court if it truly believed that the committee's work ran counter to Russia's legal obligations under the convention. Distinguished members of the court, Ukraine contends that it was possibly opposed to Russia's genocide allegations and to the measures taken by Russia to prevent and punish genocide allegation in Ukrainian territory. The fact is that all the statements quoted by Ukraine's counsel to support this claim were made by authorities being looked into by the investigative committee. And these authorities themselves were addressing these statements to the committee itself. Thus, they were not responding to a state allegation, and their attitude cannot contribute to the occurrence of a legal dispute. Turning to the speech made on 23rd February 2022 by Mr. Kuleba, the Ukrainian Minister of Foreign Affairs, he clearly did not refer to a genocide allegation or to the Genocide Convention. Council for Ukraine does not contradict this fact. She said, and I quote, although Mr. Kuleba chose not to amplify the accusations of genocide made by Russia, he clearly and forcefully defended the actions of his government in Donbass and condemned the illegal recognition by Russia of the DPR and the LPR. Last Monday, I explained why Ukraine's reference to the Foreign Affairs Minister declaration on 26 February 2022 is of no use whatever to it. I demonstrated that the court has taken account of the reasonable amount of time which passed between the existence of the dispute and the filing of the application. Now, Mrs. Cheek responded that in view of the speed of the Russian invasion, the moment and the way in which the declaration was published does take nothing away from its relevance to confirm the existence of dispute referring to the Genocide Convention at the date of Ukraine's application. This argument, however, shows yet again that Ukraine has misused the 1948 Convention. Ukraine's underlying objective in filing the application is to obtain from the court a decision on Russia's military operation. In fact, the reason why Ukraine seized the court was not the genocide allegation, but the issue of the use of force. Reacting to the genocide allegation as an alleged violation of the 1948 Convention cannot be done through military means. Positive and clear opposition to the verbal allegation genocide was required. There has been no such opposition. The Council of Ukraine stated that the Ukrainian minister published a statement before filing the application and added, and I quote, "It is reasonable to presume that under circumstances of war, the Russian Federation would have monitored very closely any official declaration made by the Ukrainian Ministry of Foreign Affairs. This argument is untenable." The declaration was published just 4 hours before the filing of the application. This is simply not enough. The court's position as to the moment of the crystallization of the dispute is totally unambiguous. It has clearly stated that the rule according to which dispute must be exist at the time or prior to the filing of the application clearly shows it should be done before the application. Therefore, the defendant would have the possibility to react to the claim made by the applicant. I've just got a couple of pages left, Madam President, if I may continue, or should I stop now for a break?
Mr. Azari, you indeed are quite close to the end of your remarks, so please go ahead and complete them, and then we'll take the break.
Okay. Thank you. Merci beaucoup, Madame la Présidente.
Thank you, Madam President. The Russian Federation was not in a position to react to the applicant's claim as expressed in the said declaration, all the more so since it was not supposed to have been informed. It must be recalled that in the Marshall Islands case, the court did not uphold the declaration made by the Marshall Islands during the Nayarit conference as evidence of an existence between dispute with the parties, despite the fact that it contained a precise allegation on the alleged breach by the defendant of its international obligations. Why? Well, because, stated the court, the United Kingdom was not present at the Nayarit conference. One cannot assume that the defendant knew that its views were positively opposed by the applicant. Mrs. Cheek's contention, according to which Ukraine's self-defense actions against Russian aggression demonstrate in a way that Ukraine, by its action, opposed the purported genocide allegation, is unconvincing. With regard to a similar contention made by the applicant in the Georgia versus Russia case, the court stated that there was no link between the so-called exercise of self-defense and opposition to the alleged breach of the treaty invoked in dispute. The court's statement can be seen on the screen, and I quote, "The Russian Federation stated that through its military aggression, observed that this, I beg pardon, and that its military aggression required the exercise of right of self-defense as provided in Article 51 of the Charter and other documents. The court observes that this decree does not allege that the Russian Federation was in breach of its obligations relating to the elimination of racial discrimination. Its concern is with the allegedly unlawful use of armed force." End of quotation. Distinguished members of the court, this brings me to the last part of my presentation, the purported dispute relating to the abusive use of the convention condemned by Ukraine in its memorial. Last Monday, I explained why none of the prerequisites for the existence of a dispute were met by this claim. Last week, Ukraine said not a word about my contentions. This being said, I shall end by repeating the main aspects of my submissions regarding this purported dispute. 1. Ukraine's claims relating to the abusive use of the convention are all based on false premises, according to which the Russian Federation had invoked Ukraine's responsibility for the Donbass genocide, and that it subsequently reacted unilaterally to put an end to it. This is wrong. There is no disagreement between the parties on this issue. When the parties, on the one hand, and the court, on the other hand, agree that there is no right under the convention, it would be absurd to complain then that there exists or may exist a dispute in its regard. 3. The Russian Federation became aware of Ukraine's claim at the time of the filing of its memorial. Yet, at the critical date of the filing of the application, this contention did not exist. Under those circumstances, one cannot conclude to the existence of a legal dispute between the parties on this count. For all these reasons, distinguished members of the Court, the Russian Federation requests that the Court decline to exercise its jurisdiction to entertain Ukraine's application in light of the absence of a dispute between the parties. Distinguished members of the Court, this brings me to the end of my presentation. I would like to thank you most warmly for your kind attention and would request that you, Madam President, call upon Mr. Alfredo Cruzata after the coffee break, if you so decide.
I thank Professor Azari. Before I invite the next speaker to take the floor, the Court will observe a coffee break of 10 minutes. The sitting is adjourned. Please be seated. The sitting is resumed, and I shall now give the floor to Mr. Alfredo Cassato to address the court. You have the floor, sir.
Madam President, distinguished members of the court, I shall now respond on behalf of the Russian Federation to what Ukraine said last Tuesday concerning the court's lack of jurisdiction ratione materia under Article 9 of the Genocide Convention. My presentation will be structured as follows. First, I will recall why Ukraine's claims do not concern an alleged breach of the Genocide Convention. I shall briefly address the conditions which, according to the court's jurisprudence, must be met for the application of the Convention to be triggered in the first place: the existence of genocide or of a risk of genocide. Even accepting, arguendo, Ukraine's own factual claims, you should find that there is no jurisdiction in the present case. The Convention is simply not applicable. Second, I shall set out the correct interpretation of Article 9 of the Convention. This compromissory clause cannot expand the court's jurisdiction, as Ukraine seems to suggest, beyond disputes regarding alleged breaches of the Convention itself. The court has already interpreted Article 9 and determined its scope. That interpretation, the court's interpretation, is the one to follow. Third, I will respond to what little Ukraine had to say regarding an all-encompassing incorporation of all of international law into the Convention, allegedly implied in Articles 1 and 4. Ukraine cannot sustain the existence of such a sweeping obligation consistent with the generally accepted rules on treaty interpretation and the court's jurisprudence on this matter. Fourth, I shall respond to what Ukraine said on abuse of rights. There is no doubt by now that Ukraine cannot identify any right under the Convention for purposes of applying an abuse of rights doctrine. Its hesitant suggestion that the Convention may contain a right of humanitarian intervention, a controversial exception to Article 2, Paragraph 4 of the UN Charter, cannot be countenanced by the court. Fifth, I will address what appears to be Ukraine's last line of argument, a general reliance on the principle of good faith, or pacta sunt servanda. The exact effect that Ukraine wants to give to these general principles does not emerge clearly from its pleadings. But there is one thing that certainly cannot be achieved by relying on good faith alone: creating new obligations under the Genocide Convention, and thus expanding the court's jurisdiction under Article 9. Ukraine's submissions, CND in its memorial, and its entire prayer for relief cannot be based on this principle alone. Madam President, members of the court, as we showed last week, the case before you does not, in the words of Article 9, concern interpretation, application, or fulfillment of the Genocide Convention. Ukraine claims relate to an alleged violation by Russia of the UN Charter and customary international law. We are not here today to discuss the merits of Ukraine's allegations, but whether the court has the power to rule on them. To entertain Ukraine's claims, the court must have an appropriate basis of jurisdiction, consistent with the fundamental principle of state consent. Article 9 of the Genocide Convention does not afford that basis. That the case is not about the Genocide Convention has become even more evident after listening to the interveners and to Ukraine. Their pleadings referred throughout to allegations of violations by Russia of the provision of the use of force, the provision of aggression, Ukraine's sovereignty, the provision of war crimes, the provision of war crimes against humanity. These are all very serious claims, but these are not claims relating to the Genocide Convention. And in all the time available to them, Ukrainian interveners failed to address the one matter that they should have addressed: the court's previous decisions concerning Article 9 of the Convention, which clearly establish the limits of jurisdiction under that provision. This disregard for your jurisprudence makes one thing clear: the goal is to go beyond, far beyond, the confines of the Convention, to bring before you alleged breaches of obligations that do not arise under the Convention itself. The implications for all states bound by Article 9 are obvious. It is enough to glance at Ukraine's prayer for relief, which is now on your screens, to realize that this case is not about the Genocide Convention. This does not read like a relief one would seek from a state that has breached its obligation to prevent genocide or its obligation to punish genocide. Ukraine's request for compensation does not concern compensation of victims for acts of genocide. It asks the court to award damages for all losses that may arise from the ongoing armed conflict. This prayer for relief, in short, does not have any connection with potential breaches of the Genocide Convention. Ukraine's heavy reliance on your order on provisional measures is also revealing. Russia did not address this issue in its preliminary objections because it is simply irrelevant at this stage of the proceedings. Ukraine's suggestion appears to be that it may bring a claim against Russia based on a breach of the order, even if Ukraine's primary claims are dismissed for lack of jurisdiction ratione materia. The fact that Ukraine advanced this argument in such length shows once more where the real objective lies, having the court address matters related to the use of force as opposed to the Genocide Convention itself. Last week, we explained that according to the court's 2007 judgment in the Bosnia genocide case, the obligations to prevent and punish genocide are triggered when genocide has been committed or when there is a serious risk that it may be committed. The court also clarified that a state can be held responsible for breaching the obligation to prevent only if genocide was actually committed. This is confirmed by the order on provisional measures in the legality of use of force cases, where the court considered that it did not have jurisdiction ratione materia, even on a prima facie basis, because there was no evidence of genocidal intent of the parties accused of committing genocide by Yugoslavia. So put simply, the Convention does not become applicable in the first place unless there is indeed a genocide or a serious risk thereof. A state cannot be held responsible for violating Articles 1 and 4 if genocide has not happened. The court's jurisprudence in this regard confirms that the Convention deals exclusively with issues relating to genocide, with actual acts or risk of genocide. Ukraine states that the facts it alleges should be accepted by the court pro tem at this stage of the proceedings. Among the facts alleged by Ukraine is that no genocide has been committed in Donbas, that there is not even a risk of genocide. If the court accepts this arguendo, then the conclusion should be that the Convention is simply not applicable in the present case. There would be, following your jurisprudence, no obligation that could have been breached, no jurisdiction ratione materia under Article 9. This alone should be enough to dismiss Ukraine's claims. Declaring that the objection does not possess an exclusively preliminary character would be a departure from the Bosnia genocide and legality of use of force cases. The court would need to determine that the Convention may become applicable even where no genocide has occurred, and when there is no risk of genocide, as claimed by the applicant. At that point, the Convention would clearly cease to be at issue. If this position is upheld by the court, only the legality of the use of force and the recognition of states would be left. But such legality can obviously not be assessed against the provisions of the Genocide Convention, which does not govern these matters. As we have stressed, they are regulated by the UN Charter and customary international law. Hence, Ukraine's imperative to import into the Convention obligations that do not arise under the Convention itself with all their qualifications. All this, Madam President, members of the Court, clearly precludes the establishment of the Court's jurisdiction ratione materia under Article 9. This was again confirmed last week when Ukraine urged the Court once more to defer Russia's second preliminary objection to the merits, making only some brief subsidiary remarks on the substance of this objection. But for the reasons we gave last week, there is no reason to defer this objection to the merits. Nothing prevents the Court from stating the obvious, that the Genocide Convention does not regulate matters related to the use of force and the recognition of states. There is no textual basis, no indication in the drafting history, no jurisprudence, no authority whatsoever in support of a different position. We know that Ukraine also suggested last Tuesday that Russia cannot rewrite Ukraine's application. But Russia is not doing anything of the sort. But This preliminary objection directly addresses Ukraine's submissions in the memorial and the manner in which they have been justified. Those submissions are what they are, as Counsel for Ukraine said, and Ukraine has had the opportunity to explain how they could be based on the Genocide Convention. It has failed to do so. Madam President, let me now turn to the proper interpretation of Article 9 of the Convention. At the outset, 3 brief general remarks are in place. First, Article 9 did not play a prominent role in Ukraine's memorial. It was only in Ukraine's written statement and in the submissions of the interveners that the interpretation of this provision came to the front. In the memorial, Ukraine was mainly concerned with Articles 1 and 4 of the Convention. Second, the emphasis put on Article 9 by Ukraine and the interveners suggests that they too recognize that no other provision of the Convention could be interpreted as incorporating other rules of international law and expanding the Court's jurisdiction ratione materia. In other words, it is now Article 9, what is being presented, at least by some, as the gateway for the Court to go beyond the substantive provisions of the Convention. Third, Ukrainian interveners seem to rely on Article 9 in different ways. Ukraine itself seems to argue that, under this provision, the Court has jurisdiction to hear claims regarding to an abuse of the Convention, to justify unilateral use of force, or the recognition of states within the territory of another state. As we have shown, Ukraine's reliance on an abuse of rights doctrine raises a separate problem for Ukraine, the inexistence of a right under the Convention that could have been abused in the circumstances of this case. I will get back to this shortly. But if Ukraine's suggestion is that Article 9 somehow grants jurisdiction, more generally, to rule on breaches of obligations not set forth in the Convention itself, the argument must be rejected. As we noted last week, the interpretation of Article 9 advanced by Ukraine contains many flaws. I will now explain briefly why this is so. Maître Chikaya will go into some more details later this afternoon in response to the submissions of the interveners. The first fundamental problem in Ukraine's position is that it simply ignores the fact that the Court has already clarified the scope of Article 9. We addressed this in detail. But since you were told for several hours, including by Ukraine, that Article 9 is an exceptionally broad compromissory clause, I hope the Court will indulge me for restating, only once and briefly because there is no need for more, what the correct position is. The Court has already clearly, unequivocally determined that Article 9 does not empower the Court to rule on alleged breaches of other obligations under international law not amounting to genocide. That Article 9 confines the Court to disputes regarding genocide. The jurisdiction under Article 9 is confined to obligations arising under the Convention itself. That the Court can only rule within the limits imposed by the Convention. Similarly, in the legality of use of force cases, as we noted last week, the Court did not see the allegations of genocide as bringing within the jurisdiction of the Court, under Article 9, questions relating to the use of force. Arguments were advanced by the parties on this question. Yet the Court did not consider, even proprio motu, that Article 9 could confer upon it jurisdiction over alleged violations of the UN Charter. It is surprising, Madam President, members of the Court, that last week you did not hear a single word, not one, concerning your previous decisions on this matter. Ukraine and interveners had more than ample opportunity to address them. They chose silence. This silence is revealing. It reveals in the clearest way that this case is not about an alleged breach of the Genocide Convention. If it were, they would have no problem in acknowledging your interpretation of Article 9. They cannot do this. Be that as it may, your clear and consistent interpretation of Article 9 is the correct one. To argue otherwise, Ukraine puts emphasis, for example, on the word fulfillment. But fulfillment, as Ukraine notes, simply means compliance with or performance of the rules enshrined in the Convention, determining whether a state has complied with its obligations, and if not, what the legal consequences of a breach are. That is what the Court does in all cases brought under a compromissory clause. even if it does not use the word fulfillment. This understanding is confirmed by the 2007 judgment in the Bosnian genocide case, where the court stated that the addition of the word fulfillment was not significant, and that Article 9 by itself did not impose obligations on the contracting parties. There was no disagreement among the judges on this conclusion. Judge Skotnikov, for instance, stated that the addition of this word, fulfillment, in Article 9 is not particularly significant. Similarly, Judge Tamka stated that fulfillment does not add anything to the substantive obligations of the parties to the Convention and does not expand the Court's jurisdiction ratione materia. Ukraine also refers to the phrase including disputes relating to the responsibility of a state for genocide. This is the phrase that the Court found unusual in the Bosnian genocide case, not the word fulfillment. Indeed, it was by interpreting this phrase, together with the substantive provisions of the Convention and the object and purpose, as well as the drafting history, that the Court came to the conclusion that Article 1 obliged states not to commit genocide themselves. Nothing more can be deduced from this phrase. Ukraine seems to suggest that because the word including is used, other types of disputes are not excluded from the scope of the compromissory clause. But, as Article 9 makes clear, the dispute must in all cases relate to the interpretation, application, or fulfillment of the Convention. Nothing in Article 9 could justify expanding the Court's jurisdiction to alleged breaches of other rules of international law. The Court has already said so expressly. Finally, a short word on writings. Ukraine and all the interveners refer to a book chapter written by one professor, but they cite a single sentence taken out of context. What they fail to mention is that in the same chapter, the author also explains that, I quote, "The compromissory clause does not expand the jurisdiction of the Court to areas not covered in other provisions of the Convention." And that in Bosnian genocide, I quote again, "The Court stressed the intrinsically limited jurisdiction under the compromissory clause." It appears, therefore, that the author cited by Ukraine and interveners correctly laid down the proper scope of Article 9 of the Convention, having due regard to your previous decisions. In the same vein, another well-known author has noted that, and I quote, "Jurisdiction under Article 9 covers disputes under the Convention only, but not disputes relating to other rules of international law, even where they are intertwined with allegations of genocide." To conclude on this point, Madam President, members of the Court, there is nothing exceptionally broad about Article 9 of the Convention. It has the same scope as other compromissory clauses under the auspices of the United Nations. It limits the Court to alleged breaches of the Convention itself. Article 9 most certainly does not impose additional obligations on the contracting parties. The compromissory clause cannot serve to incorporate other external rules into the Convention. Madam President, let me now turn to Ukraine's attempt to incorporate rules into the Convention through an alleged obligation under Articles 1 and 4 to act within the limits of international law. I can be brief because Ukraine did not have much to say last Tuesday. It was only suggested that Ukraine did not seek an incorporation in this case, that the Bosnian genocide case and the order on provisional measures in this case sufficed to determine this issue, and that the object and purpose of the Convention could lead to an incorporation. Madam President, the meaning of incorporation is well known, and the Court has never admitted such an argument to date. Incorporation means importing into a treaty rights or obligations that do not arise under the treaty itself. States sometimes seek to incorporate external rules as self-standing, independent rules within a treaty, as was the case in oil platforms. Sometimes states argue that external rules to a treaty are reflected in certain provisions of the treaty. That was the case in certain Iranian assets. And at times, states maintain that a treaty includes rules arising from other sources of international law, so as to address the manner in which a state has to perform its obligations under the treaty in question, whether they executed their obligations under the treaty without breaching other rules of international law. This was the case in immunities and criminal proceedings. It is also quite evidently the manner of incorporation that Ukraine seeks to rely on in this case. Last week, we pointed out that accepting Ukraine's position would open the door for all kinds of disputes unrelated to the Convention be brought to the Court invoking Article 9 alone. A few examples may help illustrate this point. A state could, for example, institute proceedings against another state for an alleged violation of the customary rules on the immunity of state officials from foreign criminal jurisdiction for prosecuting an official for genocide pursuant to Article 4 of the Convention. A state may also come to the court to challenge the legality of unilateral measures or sanctions adopted by another state on the basis of allegations of genocide. Such measures, which are not uncommon in cases of an alleged genocide, may be claimed to be in violation of a myriad of rules of international law with no connection to the Convention itself, depending on the circumstances. And of course, the claims I am speaking of may not only concern the legality of measures that could be adopted by states in the future. States may also seek to challenge the legality of past measures. Nothing in principle would prevent this if the parties have accepted the court's jurisdiction under Article 9 of the Convention. It is precisely because of the endless scope of disputes that could be brought under a compromissory clause, unrelated to the substantive provisions of the treaty in question, that the court has consistently rejected attempts of incorporation. As the court stated in Djibouti versus France, the consent allowing for the court to assume jurisdiction must be certain. Whatever the basis of jurisdiction, the attitude of the respondent state must be capable of being regarded as an unequivocal indication of the desire of that state to accept the court's jurisdiction in a voluntary and indisputable manner. The court made a similar point in the Croatia genocide case, where it was stated that a discernible intention is necessary to expand the court's jurisdiction beyond interpretation, application, or fulfillment of the Convention itself. In that case, the court concluded that Article 9 did not confer jurisdiction on the court even regarding claims of breaches of customary obligations regarding genocide, that is, external rules having the same subject matter as the Convention. It follows, Madam President, that Ukraine's attempt to incorporate other rules of international law, including the UN Charter, cannot prevail. The text of the Convention does not come close to showing an intention, a discernible and certain intention, by states to incorporate those other rules and to submit their disputes to the court. The drafting history is of no assistance either, nor is the object and purpose of the Convention, important as it is, because it cannot suffice in itself to expand the court's jurisdiction beyond what states have consented to. As we showed last week, the Bosnia genocide case cannot be relied upon either. When the court said that every state, not the contracting parties to the Genocide Convention specifically, may only act within the limits of international law, that was a general statement of law, not a conflation of obligations arising under different sources, or an expansion of jurisdiction under Article 9. Again, in the same judgment, the court determined that jurisdiction only covers alleged breaches of the Convention itself. In immunities and criminal proceedings, the court was careful in delineating the subject matter and scope of the specific treaty in relation to other rules of international law, even if those other rules may have been breached when executing the specific treaty, and even in the face of express language that could have led to an incorporation. The same approach is clearly also applicable in the present case. Again, in the Bosnia genocide case, the court was simply clarifying in which circumstances a state may not be found responsible for failing to prevent genocide. The court avoided putting states in the situation where they would face conflicting obligations. Ukraine also relies almost exclusively at this point on your order and provisional measures. But the order in no way prejudges the question of the jurisdiction of the court or any question relating to the merits. It is now that the court is called upon to determine the question of jurisdiction, having before it the full arguments of both parties. Ukraine also refers to the court's finding in Bosnia genocide that states have an obligation not to commit genocide themselves, even if this is not stated expressis verbis in the Convention. But as I noted some moments ago, the court arrived at this conclusion after a careful interpretation of the actual text of the Convention, in particular its Article 1, the object and purpose, and the drafting history. This step was taken, I would add, with respect to an obligation that goes to the heart of the Convention. In the present case, the suggestion that the Convention obliges states, by implication, to comply with all their obligations under international law has no basis. Has no basis in the text or the drafting history of the Convention. And accepting Ukraine's position would lead to similar implicit obligations we read into all treaties, with ensuing consequences for the system of compromissory clauses. To be clear, Russia's position is not that states do not have to comply with their obligations under international law when executing or giving effect to the Convention or to any other treaty. The position is simply that this is not a treaty obligation under the Convention itself. The Court's jurisdiction retaining materia under Article 9 cannot be expanded on this basis. Madam President, members of the Court, I now turn to Ukraine's reliance on an abuse of rights doctrine. As we explained last week, for this argument to have merit, Ukraine must first establish the existence of a specific right under the Convention that may be the object of abuse. Ukraine does not contest that a right that does not exist cannot be abused. It does not contest that the alleged abuse of a right that does not exist under the Convention cannot be the subject of proceedings under Article 9. We also showed that Ukraine's position regarding the precise right that was allegedly abused in this case is obscure. Ukraine does not say anything, for example, about the right to recognize states under the Convention, even though the recognition of the DPR and LPR also forms part of its submissions. And when it comes to the unilateral use of force, Ukraine suggests that the Convention confers such a right, only to then deny that they exist under the Convention. The slide on your screen shows Ukraine's clear hesitance to assert the existence of a right to use force. Madam President, members of the Court, Ukraine's hesitance is understandable because it cannot be seriously suggested that the Convention confers a right to unilaterally use force, a right of humanitarian intervention. The use of force is regulated by the UN Charter and customary international law. The inexistence of a right of humanitarian intervention was confirmed by states in the 2005 World Summit Outcome document. Reading a right to unilaterally use force into the Convention would entail creating a novel exception to Article 2, Paragraph 4 of the Charter. Such an interpretation of the Convention would have no basis whatsoever in the text or the drafting history of the treaty. Issues relating to the use of force, again, do not fall within the scope of the Convention. Another problem with Ukraine's position is the way it argues that Articles 1 and 4 of the Convention contain rights and obligations at the same time. By doing so, Ukraine seems to agree that an abuse of rights doctrine may only apply to rights, not to obligations. It could, of course, not be otherwise. But Ukraine is wrong to suggest that the prevention and punishment of genocide are rights of states. The difference between obligations and rights is straightforward. An obligation is something that a state is obliged, mandated to do. If the obligation is triggered, the state must comply with it. In case of breach, the law of state responsibility will apply to determine the legal consequences. Rights, for their part, are something states are free to exercise. States are not required to exercise a right. The Court jurisprudence makes clear that Articles 1 and 4 impose obligations. As the Court noted in Bosnian genocide, I quote, "The ordinary meaning of the word undertake is to give a formal promise, to bind or engage oneself, to give a pledge or a promise, to agree, to accept an obligation. It is a word regularly used in treaties setting out obligations." End of quote. These obligations are of an erga omnes partes character. They are owed to all the other contracting parties of the Convention. The only correlative right for a state arising under Articles 1 and 4 is to invoke compliance with those obligations by other states when they are required to do so. As the Court noted in the Gambia versus Myanmar case, this includes the possibility to invoke the responsibility of the state which has failed to prevent genocide, which, in the case of the Convention, is contained in Article 9. So it is wrong to suggest that Articles 1 and 4 confer on states a discretionary power. What may be expected from each state in fulfilling its obligation may vary depending on the circumstances, as the Court clarified in Bosnia genocide. But states still have the obligation to act. To say that states have a discretionary power would significantly weaken, if not altogether deny, the obligations to prevent and punish. Ukraine's reference to Djibouti versus France is irrelevant for the purpose of this case. In that case, the court was dealing with a dispute regarding mutual legal assistance. The treaty in question gave France discretion to refuse requests for assistance based on certain defined criteria. No analogy can be drawn between that treaty and Articles 1 and 4 of the Genocide Convention, which impose clear obligations on the contracting parties. Also in opposite is Ukraine's reference to the work of the Institute on obligations erga omnes in international law. In its 2005 resolution, the Institute was dealing with action that states may take under the law of state responsibility when facing the breach of an erga omnes obligation, such as invoking responsibility and requesting compliance with that obligation. Articles 1 and 4 of the Convention contain primary obligations incumbent upon all contracting parties. They should not be confused with secondary rules. Madam President, it is true that in the circumstances of the immunities and criminal proceedings case, the court found that the arguments relating to an abuse of rights were something for the merits. But the court did not say that this must always be the case. It does not have to be the case when a respondent is accused of abusing a right that manifestly does not exist under the treaty invoked. It cannot be the case when the applicant cannot openly and clearly state what that right is, and when the respondent does not claim any right. And it certainly cannot be the case when admitting the existence of the right would create an undefined exception to Article 2, Paragraph 4 of the UN Charter. In short, Articles 1 and 4 impose obligations on states. They do not create rights, and they most certainly do not confer a right to unilaterally use force or to recognize states within the territory of another state. Ukraine's submissions, based on an abuse of rights doctrine, must therefore be dismissed for lack of jurisdiction ratione materiae. Madam President, I now move on to what appears to be Ukraine's last line of argument, having failed to identify a right under the Convention for purposes of applying an abuse of rights doctrine. A more general reliance on the principle of good faith, as reflected in Article 26 of the Vienna Convention on the Law of Treaties. On Tuesday, Counsel for Ukraine stated that a state cannot invoke and execute its obligations under the Convention in a manner contrary to the object and purpose of the Convention. He suggested that since Article 1 does not specify the actions a state may adopt to prevent genocide, it confers a discretionary power on the contracting parties, which must be exercised reasonably and in good faith. And he added that an example of abuse of that discretionary power is falsely claiming a genocide with the objective of claiming a right to act to the detriment of another state, including by using force. Ukraine does not say so expressly, but the suggestion appears to be, in line with Ukraine's general strategy in this case, that if a state does not execute its obligations under Articles 1 and 4 of the Convention in good faith, that the jurisdiction of the court under Article 9 may extend to alleged breaches of other rules of international law that may be somehow linked to the improper execution of the treaty. This calls for a few remarks. First, as the court noted in border and transborder armed actions, the principle of good faith is not in itself a source of obligation where none would otherwise exist. In the present context, good faith cannot create additional obligations for states under the Genocide Convention. The principle only relates to the performance of the obligations already contained in the Convention itself. It requires states, following the judgment in the Kapchikovo-Nojmarosh case, to apply a treaty in a reasonable way and in such manner that its purpose can be realized. Second, good faith cannot be used to expand the court's jurisdiction under Article 9 of the Convention. As we have reiterated, the court requires unequivocal evidence of states' discernible, certain intention to submit disputes to the court. Such an intention could obviously not be established by reference to an abstract general principle of law. Third, as we just showed, Article 1 of the Convention does not confer a discretionary power on states. It is an obligation the states must comply with. It is true that the specific action that a state is required to take is not laid down in Article 1. But one thing is certain. That action is not the unilateral use of force or the recognition of states. These are matters that are exclusively regulated by the UN Charter and customary international law, and which do not fall within the scope of the Convention. This last point is particularly important. The principle of good faith may only apply in proceedings under Article 9 of the Convention to the extent that the obligations under the Convention itself are at issue. If the conduct of a state does not fall within the scope of the Convention, such as the use of force, one cannot use Article 9 to apply the principle of good faith in relation to the conduct not arising under the Convention. Ukraine's reliance on Article 4 of the Convention illustrates this point well. This article only concerns criminal proceedings and the prosecution of perpetrators of genocide. If a state, in the belief that a genocide was being committed, invoked this provision to use force, which Russia denies is the situation in this case, that mere invocation would have no bearing on the legality of such action under Article 4, which does not regulate the use of force. The legality of that conduct will be appraised by reference to the UN Charter and customary international law, but not the Genocide Convention itself, and so would not fall within the compromissory clause of Article 9. The same would be true for an invocation of Article 1 of the Convention for the same purpose. That article has no connection to matters relating to the use of force. So the problem with Ukraine's argument is that it continues to conflate conduct that falls within the scope of the Convention with conduct that falls clearly outside its scope, or, as Ukraine puts it in its memorial, ultra-vires conduct. The use of force and the recognition of states are issues that manifestly do not fall under any provision of the Convention. The legality of the use of force and of recognition cannot be assessed, therefore, within the terms of the Convention. The UN Charter and customary international law regulate those matters, and the principle of good faith cannot affect this. Madam President, members of the Court, to conclude, Ukraine instituted the present proceedings invoking Article 9 of the Genocide Convention. The Convention does not regulate matters relating to the use of force. It does not regulate matters relating to the recognition of states. Article 9, as the Court has already determined, limits jurisdiction to alleged breaches of obligations arising under the Convention itself. The Court must also reject Ukraine's conclusions C and D of the memorial, inasmuch as they require the Court to exercise jurisdiction over alleged breaches of all the rules of international law and order reparation for those alleged breaches. Specifically, the Court's jurisdiction ratione materia cannot be established in the present case for 5 reasons. 1. Even accepting Ukraine's own alleged facts arguendo, the provisions of the Convention have not been triggered, and the Convention is therefore not applicable in the circumstances of this case. 2. The Court has already established that jurisdiction under Article 9 is limited to alleged breaches of obligations arising under the Convention itself. It does not confer on the Court broader jurisdiction. 3. The Convention itself does not impose an obligation to act within the limits of all of international law when executing or giving effect to the Convention. Such a sweeping incorporation cannot be established as a matter of treaty interpretation, bearing in mind the Court's jurisprudence. 4. The Convention does not confer a right on states to unilaterally use force or to recognize states within the territory of another state. In the manifest absence of these rights, Ukraine cannot rely on an abuse of rights doctrine. And 5. The general principle of good faith may not be used to expand the Court's jurisdiction beyond that conferred by Article 9. Madam President, members of the Court, this concludes my presentation and Russia's presentation for this morning. Thank you for your kind attention.
I thank Mr. Cassato, whose statement brings to an end this morning's session. The Court will meet again this afternoon at 3 p.m. to hear the remainder of the second round of the Russian Federation. At the end of that sitting, the Russian Federation will present its final submissions. The sitting is adjourned.
to what Ukraine claimed in its application. It is now undisputed that Ukraine made new claims in the memorial. The question then is whether these adjustments, additional claims, or new claims, or what have you, are admissible in line with the Nauru criteria as applied in Nauru and progeny. Ukraine does not contest, thus accepts Russia's reliance on Nauru. However, its analysis fails to take into account the factors that Nauru judgment considered decisive for finding new claims inadmissible. I discussed these elements last Monday, and for convenience, let me just recall them here. First, the application is the basis on which it is to be determined whether or not a claim is new. As the court emphasized in Diallo, and I quote, "In this respect, it is the application which is relevant." Second, a new claim is not inadmissible ipso facto. The decisive consideration is the nature of the connection between the claim and the one formulated in the application. Third, regarding the nature of such connection, to find that a new claim has been included as a matter of substance in the original claim, it is not sufficient that there should be links between them of a general nature. Fourth, to be admissible, a new or additional claim must have been implicit in the application or must arise directly out of the question, which is the subject matter of the application. Russia addressed each of the new claims it considers inadmissible based on the Nauru criteria. On the other hand, Ukraine, as I pointed out last Monday, could only muster in its written statement links of a general nature between its new claims and the original claim, and offer only conclusive statements with no concrete support that the Nauru alternative tests were met. Such general links and conclusive statements obviously are not sufficient to show that the new claims are admissible under the Nauru criteria. Last Tuesday, Ukraine did not go any further beyond what it did in its written statement. In fact, Ukraine remains evasive on most of the points raised by Russia and offers all over again statements on a general connection and conclusory assertions about the connection between the new claims and the original claim or the subject matter of the dispute. Nevertheless, let us take a look at Ukraine's assertions made last Tuesday. Ukraine's first assertion is essentially that its new violation of the Convention claims are the no basis in the Convention claims, or they are of the same nature. The first basis for this assertion seems to be a few phrases Ukraine seized upon in its application. In Russia's preliminary objections and in my presentation last Monday, we have made clear the glaring differences between the two types of claims. In any event, these phrases Ukraine seized upon are of no help to Ukraine. First, Ukraine claims that its assertion Russia's actions are incompatible with the Convention is a claim that Russia violates the Convention. Nothing can support this view. An ordinary meaning of incompatible is having basic differences. Of course, use of force and recognition of states are based on different bodies of law, and for this reason, they are incompatible with the Convention. This, however, does not mean they violate the Convention. Second, Ukraine states that its contention, Russia's actions violate Ukraine's rights, indicates that Russia violated the Convention. This is also baseless. Even now, Ukraine fails to indicate a right envisaged by the Convention that Russia violated. Needless to say, the application did not point to that right and the provision of the Convention on which this right is based. Third, to support its purported claim on Russia's violation of the Convention, Ukraine relies on a vague submission in paragraph 30b of the application that Russia cannot lawfully take any action on the basis of the Genocide Convention, on the basis of the false claim of genocide. This reference does not help it either. It is common ground that the Genocide Convention does not provide a legal basis for use of force or recognition of states. However, Ukraine's declaratory submission in no way alleges Russia's responsibility under the Convention. Last Tuesday, Counsel for Ukraine attempted to rewrite the wording of its claim to say that Russia cannot lawfully take the action it was taking. The application does not contain such wording, "it was taking," or any other wording invoking Russia's responsibility under the Convention. Thus, the phrase "cannot lawfully take," read together with other phrases and other requests, means only having no basis in the Convention. The second basis for Ukraine's same claims assertion is that the court understood the nature of Ukraine's case in its provisional measures order, summarizing Ukraine's position as follows. The Russian Federation has acted inconsistently with its obligations and duties as set out in Articles 1 and 4 of the Convention. But as I pointed out last Monday, in the order on provisional measures, the court was not expressing an opinion, but simply relating what Ukraine argued orally during the hearing on provisional measures. In other words, Ukraine only mentioned such responsibility or Article 4 in its Council statements post-application. This mention does not have the effect of retroactively invoking in Ukraine's application Russia's responsibility under Articles 1 and 4 of the Convention. As mentioned several times, the court has emphasized that in this respect, it is the application which is relevant. Ukraine's second assertion is that Russia's third preliminary objection flouts the law for three reasons. In the first leg of this assertion, Ukraine first recaps the Nauru criteria and then essentially asserts that the subject matter of the dispute is and always has been the same: Russia's reliance on allegations of genocide to justify harming Ukraine. That each submission arises directly out of Russia's actions in reliance on its allegations of genocide. That Ukraine's application asked for more than a declaration that Russia's actions lacked a basis in the Genocide Convention. But even if that had been the sole request, the question of whether Russia's actions could be justified under the Convention is closely related to whether those same actions violate the Convention. They stem from the same dispute. These statements only describe in general terms the general connection between the new claims and the original claim. They stem from the same dispute, or offer conclusory observations without proof that each submission arises directly out of Russia's actions in reliance on its allegations of genocide. This is not sufficient to meet the Nauru criteria. In making such assertions, Ukraine attempts to generalize or extrapolate the subject matter or dispute. I quote, "The subject matter of this dispute is, and always has been, the same: Russia's reliance on allegations of genocide to justify harming Ukraine." First of all, no such formulation appears in the application at all. Secondly, the main targets in the application, Russia's special military operation and recognition of the DPR and LPR, have been extrapolated as measures harming Ukraine. Ukraine apparently wants to cast the net widely and loosely so that it can take in all claims. However, such an approach violates Article 38(2) of the Rules of Court, which requires the precise nature of the claim to be specified in the application. Thirdly, It is also against the teachings of the World Court, this court and its predecessor in many cases. For example, Mavromatis says that a dispute is a disagreement on a point of law or fact. Where is the point of law or fact in such an overall subject matter? If I may paraphrase the term overall problem Iran used to describe its grand controversy with the United States in Tehran hostages, such overall subject matter must be reduced to a series of specific issues such that a court could deal with them to meet the requirements of the statute, the rules, and the case law of the court. Such an overall subject matter approach must be rejected, as the court rejected the overall problem formulation in Tehran hostages. The second leg of Ukraine's assertion is that Russia improperly focuses on the wording of Ukraine's requests for relief. It seeks help from a few phrases in the application and in different requests for relief. As the most important component in an application, the requests for relief are naturally the place for one to look for the real subject matter of the dispute, particularly when an application, as is Ukraine's, does not make the subject matter clear. In any event, as analyzed here, the phrases in the application and in other requests that Ukraine seized upon do not offer any rescue to its inadmissible new claims. In this regard, Ukraine resorted to Nicaragua versus Colombia as a precedent in its favor. But to the contrary, that case offers no help to Ukraine. Instead, it showcases why Ukraine's new claims are inadmissible. In that case, Colombia asserts that in its reply, Nicaragua changed its original request and that the new continental shelf claim was not implicit in the application nor in the Nicaraguan memorial. Colombia states that the question of Nicaragua's entitlement to a continental shelf extending beyond 200 nautical miles, hereinafter referred to as extended continental shelf, and the delimitation of that shelf based on geological and geomorphological factors cannot be said to arise directly out of the question that was the subject matter of the application, namely the delimitation of a single maritime boundary based solely on geographical factors. The court agrees that Nicaragua's additional claims are new, but proceeds to reject Colombia's objection to admissibility. Thus, and I quote, the court notes that the original claim concerned the delimitation of the exclusive economic zone and of the continental shelf between the parties. In particular, the application defined the dispute as a group of related legal issues subsisting between the Republic of Nicaragua and the Republic of Colombia concerning title to territory and maritime delimitation. In the court's view, the claim to an extended continental shelf falls within the dispute between the parties relating to maritime delimitation and cannot be said to transform the subject matter of that dispute. Moreover, it arises directly out of that dispute. What has changed is the legal basis being advanced for the claim, natural prolongation rather than distance as the basis for a continental shelf claim, and the solution being sought, a continental shelf delimitation as opposed to a single maritime boundary, rather than the subject matter of the dispute. The new submission thus still concerns the delimitation of the continental shelf, although on different legal grounds. End of quote. Ukraine says that Ukraine's adjustments to its submissions here are far less dramatic than Nicaragua's change of request. Ukraine misses the point. As the court explains, the subject matter of the dispute in Nicaragua in specific terms, i.e., ultimate delimitation of the EEZ and of continental shelf between the two parties, has not changed. The only change is the basis for the claim and solution, Put another way, the method of delimitation. The different solutions are just different ways to achieve the ultimate result of delimitation. Here, in this case, there is no such close connection between Ukraine's new claims and its original claim, as we have shown in our preliminary objections and in my presentation last Monday. As a result, Ukraine's new claims are inadmissible. In this leg of Ukraine's assertion, in response to Russia's argument that by changing the request in the application for a declaration that no act of genocide have been committed to a request in the memorial for a declaration that there's no credible evidence that Ukraine is responsible for committing genocide in violation of the Genocide Convention, Ukraine presented an inadmissible new claim. Ukraine simply asserts general connections between the two. I quote, "Both formulations arise from the same dispute with the same subject matter," or that the fact that Russia acted against Ukraine without any such evidence is relevant to Ukraine's claim of abuse, also an integral part of Ukraine's application. Such arise from or is relevant language denotes only general connections, which are insufficient to meet the Nauru criteria. The third leg of Ukraine's second assertion is that its failure to mention Article 4 in the application does not matter. Counsel for Ukraine argues that, and I quote, "Ukraine claims that Russia improperly sought to punish Ukraine and its officials as persons committing genocide, even though they are not such persons." Again, this claim arises directly out of the subject matter of the application. Russia's actions taken for the express purpose of preventing and punishing genocide. Madam President, distinguished judges of the court, what a surprising novel argument this is. We all know that Article 4 only deals with criminal punishment through the criminal process, or in the words of an intervening state among the 32 that have come to support Ukraine. And I quote, "Article 4, which provides exclusively for criminal measures against individuals, cannot be interpreted in isolation." Now, counsel for Ukraine appears to consider Ukraine as a person within the meaning of Article 4 and eligible for criminal punishment, and also considers the means Ukraine describes in the application, i.e., Russia's special military operation or recognition of DPR and LPR as measures of criminal punishment. Madam President, distinguished judges of the court, to tell you the truth, there's nothing in the application that can be considered remotely related to criminal punishment, not to mention under Article 4 of the Genocide Convention. Article 4 claims, in whatever formulation, cannot be considered to have been included in the original claim. And the court's mention of Article 4 in the form of relating what Ukraine said during the oral proceedings on provisional measures does not change this. Finally, Ukraine said this case where the court has already found that Ukraine prepared its application in circumstances of extreme urgency should not be the first to adopt Russia's rigid methodology. I would like to point out that calling the Nauru criteria Russia's rigid methodology is wrong. First of all, the methodology is not rigid. It is just right for the business of a court of justice. Secondly, it is not Russia's methodology. It is the court's rule of law. The court's rule of law does not take a break for any party. It applies continuously and equally to all. And so, in this case, too. Otherwise, the court will become just another hall of unwieldy discussion as I mentioned last Monday. To conclude, Russia reiterates its request that the court declare inadmissible Ukraine's new claims presented in paragraph 178b to d and paragraph 179a to f of the memorial. Madam President, distinguished judges of the court, I now come to Russia's fourth preliminary objection. By this objection, Russia maintains that Ukraine's claims are inadmissible because any potential judgment from the court on these claims would be devoid of practical effect. And I say this with the utmost respect, the greatest respect for the court. The law on this issue is clear, and this court should only render judgments that can affect existing rights and obligations of the parties, thus removing uncertainty from their legal relations, or, put another way, judgments that would be capable of effective application or susceptible of compliance or execution. Russia has shown that any potential judgment that this court could render on Ukraine's claims made under the Genocide Convention would be devoid of practical effect. First, any potential judgment under the Genocide Convention cannot possibly or properly address the right of self-defense under Article 51 or of self-determination under Article 1 of the UN Charter and customary national law, over which the court has no jurisdiction, and therefore cannot affect the rights and obligations or remove the uncertainty in legal relations arising under these bodies of law. Second, any such potential judgment under the Genocide Convention does not prejudge the lawfulness of conduct under these bodies of law. And third, a decision made under the Convention cannot override Russia's inherent right of self-defense under Article 51, or the right to recognize states under the right to self-determination under Article 1 of the UN Charter and relevant customary international law, which are, no doubt, jus cogens. This has been noted early on in this very case. Without engaging these points directly and squarely, Ukraine on Tuesday resorted to a plethora of sideways assertions. Let us take a look at some of them. Ukraine's first assertion is that Russia mischaracterized the dispute and that Ukraine's claims are based firmly on the Genocide Convention. We can see that Ukraine firmly sticks a Genocide Convention label to its claims, for sure, but this does not mean that would suffice to make the dispute a Genocide Convention dispute. In fact, Ukraine has been playing a labeling game, while its real goal is to get the court to make a decision on and decree remedies for matters other than the Genocide Convention. As paragraph 179 of its memorial lays bare to us all, neither genocide nor Genocide Convention is mentioned once there, not even once there. The truth is, between Ukraine and Russia, there has been no dispute regarding the Genocide Convention to begin with. This is apparent even to an intervening state coming to help Ukraine. Thus, they note that neither party now argues in their submissions before the court that Article 1 and 4 themselves authorize the unilateral use of force to prevent or punish genocide. I know that the Council said belatedly, but this is not true, as Russia already made clear the basis for its special military operation is the right to self-defense under Article 51 of the UN Charter in its letter sent to the Security Council before the filing of the application. Interestingly, given that recognition, that intervening state still claims that the court would have jurisdiction to declare the Russian Federation's so-called special military operation in Ukraine was not authorized by the Genocide Convention. Russia submits that with the agreement as noted, the court is not called upon to do more, and the declaration as suggested by the intervening state will be incompatible with the judicial function of the court. With due respect, this suggestion flouts the teachings of the court in Northern Cameroon's nuclear test, Chile versus Bolivia, as well as frontier dispute, Burkina Faso, Niger. We have earlier discussed Northern Cameroon's nuclear test and Chile versus Bolivia, in which the court essentially held that the court can exercise its jurisdiction in contentious proceedings only when a dispute genuinely exists between the parties at the time of adjudication. And when no dispute exists, the court is not called upon to proceed further. In Chile versus Bolivia, the court held, if the court finds that the parties have come to agree in substance regarding a claim or a counterclaim, it will take note of that agreement in its judgment and conclude that such a claim or counterclaim has become without object. In such a case, there's no call for a declaratory judgment. And in frontier dispute, Burkina Faso, Niger, the court specifically addressed a situation analogous to the suggested declaration here. In that case, Burkina Faso and Niger reached agreement described as entente on two sectors of the boundary between them before the institution of proceedings. And the special agreement provides that the court should place on record the entente reached by the parties at the end of their negotiations. Burkina Faso requested the court to include in the operative part of its judgment the line of the common frontier in the two sectors on which the parties have agreed, so as to endow this line with the force of res judicata, while Niger did not object but did not join in the request either. The court considered that such a request is not compatible with its judicial function. Here too, before Ukraine's institution proceedings, Russia made clear that its special military operation was based on Article 51 and Article 1 of the UN Charter and customary international law, rather than grounding the operation in the Genocide Convention. Similar to the requested declaration in frontier dispute, a declaration that Russia's special military operation in Ukraine was not authorized by the Genocide Convention would be incompatible with the court's judicial function. More than once, Ukraine attempts to turn Russia's preliminary objection on admissibility of its claims into a defense on the merits, such as Russia's argument being premature or Russia's basis for its special military operation being not clear. For its assertion, Ukraine points to the statements of Russian high-level officials made on TV or on social media. Ukraine ignores Russia's formal letter of 24 February 2022 to the Security Council or its formal letter to the court dated March 7, 2022. I have discussed this issue last Monday, and it bears reiterating that all the material makes clear and manifest that Russia does not ground its military operation in the Genocide Convention. The fact, i.e., the statements and letters, are not in dispute. They exist. The issue is what effect the court should give to them. Such an issue is eminently one for the preliminary objection stage, as the court held in border and trans-border armed actions, Nicaragua versus Honduras. The documents make it very clear that the Genocide Convention is not the legal basis of the special military operation. The legal basis for the operation that is mentioned in all the documents that specifically address this issue is Article 51. I emphasize, specifically address this issue is Article 1 of the UN Charter. The mention of genocide in some statements made on TV or on social media were not stating the Genocide Convention as the legal basis for the special military operation, but was for describing the serious situation of the relevant persons. Furthermore, Russia's letter to the Security Council was delivered through an established, specific and special channel for the very specific purpose under Article 51 of the UN Charter of solemnly informing the Security Council of the resort to the use of force in self-defense. And the letter to the court was delivered through an established, specific channel for the very specific purpose of solemnly presenting legal positions to this august institution. These letters must be considered decisive for determining a state's intent in the use of force in self-defense and its legal position, respectively. Madam President, distinguished judges of the court, rhetoric on whom to listen aside, if TV and social media are prioritized over special, established, and specific channels, if statements made outside special, established channels are prioritized over specific positions made through special, established channels, the working of the international system, in particular, the standing mechanisms in place for specific purposes of dealing with the most serious, the most solemn business, use of force in self-defense and interstate dispute settlement, will be called into question. All this shows, as I have said last Monday, clearly and manifestly, that the Genocide Convention is not a legal basis for the special military operation. Finally, Counsel for Ukraine attempts to find some effect for a potential judgment of the court based on the Genocide Convention by essentially insisting on the Genocide Convention as a separate body of law applicable to the special military operation, and on the effect of the court's decision staying within that realm. In so doing, Ukraine steadfastly ignores Russia's third argument, i.e., the view that a decision made under the convention cannot override Russia's inherent right of self-defense under Article 51, or in realization of the right to self-determination under Article 1 of the UN Charter and relevant customary international law, which no doubt are jus cogens, and that as a result, any pronouncement from the court on Ukraine's claims based on the Genocide Convention would be devoid of legal purpose or would be a wholly academic exercise, thus incompatible with the court's judicial function. A charge that a decision of this august institution, this Court of Justice, would be a wholly academic exercise is a serious matter. So much so that when faced with such a charge from the United States in Nicaragua versus the United States, i.e., a decision on the use of force and self-defense based on customary international law cannot be carried out as against the commitment made regarding the same point under the UN Charter, a multilateral treaty over which the court had no jurisdiction. The court seemed to acknowledge that this indeed may be a problem, but pointed out that on use of force and self-defense, any difference between customary international law and the UN Charter will not be such that a decision of the court cannot be carried out. In the court's own words, I quote, "The differences which may exist between the specific content of each are not, in the court's view, such as to cause a judgment confined to the field of customary international law to be ineffective or inappropriate, or a judgment not susceptible of compliance or execution." In stark contrast, here in this case, what Ukraine asks from the court under the Genocide Convention, such as termination of use of force, withdrawal of recognition of DPR and LPR, is diametrically opposite to Russia's actions taken under the right of self-defense and the right to self-determination, over which the court has no jurisdiction, which are, of course, jus cogens. As we know, self-defense is enshrined as an inherent right under Article 51 of the UN Charter, thus given supreme status in our current community of states. It is also given an exalted position even in the extreme tension situations described in the court's advisory opinion of 8th July 1996. And the fundamental character of the right of self-defense, and the fundamental character of the right to self-determination has repeatedly been stressed by this court in cases such as Chagos, war in Palestine, East Timor. Its status as jus cogens is well recognized, as testified to by the work of the International Law Commission. On the other hand, while the prohibition of genocide, i.e., the act within the meaning of Article 3 of the Genocide Convention, is no doubt jus cogens too, no such jus cogens matters are in issue in this very case, because no such acts are alleged. The obligation to prevent genocide is not yet jus cogens, as persuasively held by an arbitral tribunal composed of distinguished jurists, including a sitting member of this court, sitting right now here, and a former member of this court. And I quote, "Given the high threshold required to attribute jus cogens status to an international norm, it is not enough for the Respondents' Council to say why not include the obligation to prevent genocide as a jus cogens obligation. Turkey has not been able to point to any state practice which clearly supports the contention that this obligation has been recognized by the international community of states as a whole as one from which no derogation is permitted, nor has it shown any persuasive international judicial authority to that effect." End of quote. Ukraine's claims regarding alleged bad faith in performing such an obligation to prevent is one more level removed from the obligation to prevent, and is thus farther away from jus cogens. The measures Ukraine sought from the court are, at best, prohibition of jus cogens paraphernalia, not jus cogens proper. Prohibition of jus cogens paraphernalia, prohibitions of genocide paraphernalia do not have the status of jus cogens. As the court's 2012 judgment in Germany versus Italy clearly teaches, accordingly, any measures decreed by the court in a potential decision on Ukraine's claims thus would not possess the status of jus cogens, and thus could not, I emphasize, could not override jus cogens' right to self-defense or self-determination, as the court's potential decision on Ukraine's claims would be devoid of purpose. In light of all our arguments presented in our preliminary objections and in our presentations, any potential judgment on Ukraine's claims based on the Genocide Convention would be devoid of any practical effect. Madam President, this concludes my presentation. I have the pleasure to request that you give the floor to Mr. Udovichenko to continue Russia's presentation. I thank you for your attention.
I thank Professor Yi for his statement, and I now give the floor to Mr. Kirill Udovichenko. You have the floor, sir.
Madam President, members of the court, it is an honor for me to appear before you today on behalf of the Russian Federation. I will respond to Ukraine's submissions on Russia's fifth and sixth preliminary objection, as well as on the alleged violations of the court's provisional measures order. I will start with the issue of inadmissibility of Ukraine's reverse compliance claims. Ukraine only opposed it by stating that the rights of nationals and the Lockerbie cases should apply to Ukraine's claim. Other than that, no objections were voiced. I will then limit my presentation to these remaining issues. The rights of nationals is an irrelevant and bad authority for Ukraine, not least because in this case, the US chose not to object to France's reverse compliance claim. Instead, it pursued a counterclaim that France breached the Aleppo Treaty, and further dispute revolved only around this positive statement. The Lockerbie case may require a bit more attention, especially given that recently it has been invoked by the United Kingdom, a party to that dispute. So in Lockerbie, Libya asked the court to declare that it had fully complied with all of its obligations under the Montreal Convention, and that the United Kingdom had, in turn, breached and is continuing to breach its legal obligations to Libya under a number of articles of the Montreal Convention. So how did the United Kingdom respond? It objected against Libya's non-violation complaint and stated that the United Kingdom never itself invoked the Montreal Convention. Specifically, it went on arguing that, I quote, "An assertion by the state that it is acting in accordance with the treaty does not itself create a dispute between that state and another party regarding the application of that treaty." May I remind you that this is the United Kingdom arguing in Lockerbie against the admissibility of a reverse compliance request. This is the same United Kingdom that now, together with Ukraine, suggests that in the Lockerbie judgment, the court has accepted Libya's reverse request. However, the plain text of the judgment suggests that the court simply excluded Libya's non-violation claim from the scope of the dispute. This has not been done manifestly, but both a general and a specific description of the dispute by the court, which you see on the slide, do not even remotely refer to Libya's compliance with the Montreal Convention. What the court did do manifestly is limit its competence to cover only Libya's claims concerning the United Kingdom's alleged violations of the Montreal Convention. I quote, "Indeed, it is for the court to decide, on the basis of Article 14, paragraph 1 of the Montreal Convention, on the lawfulness of the actions criticized by Libya, insofar as those actions would be at the variance with the provisions of the Montreal Convention. Naturally, actions criticized by Libya can in no way imply Libya's own compliance with the Montreal Convention. Russia accepts that there are matters where this matter can be interpreted in two ways. One is that the court did not pronounce on the admissibility of the reverse compliance claims at all. The other is that even if it did so in a manner not allowing such claims. In either scenario, the Lockerbie judgment supports Russia's case, not Ukraine's. Another statement which requires some scrutiny is Ukraine's argument that, unlike the Genocide Convention, the Montreal Convention did not contain the express indication that any of the parties to the dispute may seize the court. Well, the compromissory clause in Article 14 of the Montreal Convention is very clear in this respect. I quote, if the parties are unable to agree, any of those parties may refer the dispute to the International Court of Justice by request. So there is no real difference between the Montreal Convention and the Genocide Convention as regards to who can bring the claim. Article 9 of the Genocide Convention, just like Article 14 of the Montreal Convention, in the Lockerbie case, sets out the scope of Russia's consent to the court's jurisdiction. The scope of jurisdiction means that if two states have divergent views as to the interpretation, application, or fulfillment of the convention, either can then refer the issue to this court. Russia has never argued that only Russia can invoke Ukraine's responsibility under the Convention, while Ukraine can never invoke Russia's responsibility. What Russia did argue, however, was that the claim shall be filed by a state that invokes responsibility of the other state. A state cannot invoke responsibility under the Genocide Convention by claiming absence of its own breach of the Convention. Likewise, a state cannot preempt any further responsibility of its own for genocide by obtaining a negative declaration that such genocide was not committed. Ukraine's criticism that Russia had sufficient time, that is 8 years, to investigate and gather evidence of genocide in Donbass misses that point. The point, however, is that no one can take from the state its sovereign right to decide if, when, and how it wishes to bring a claim. Finally, I also note that the interveners argue that a state can file a premature non-violation claim in order to, I quote, clear its name. Now, I cannot align myself with the idea that this court, being a proper place for handling some states' reputational issues. Clearly, further elaborations on such suggestions appears to be excessive. Madam President, this concludes my final comments on Russia's fifth preliminary objection, and I would now move to the sixth. Ukraine did not raise much objections to Russia's abuse of process argument. In essence, it asserted that, I quote, Russia's allegations of abuse add nothing to its other objections. It is rewarding to see that the parties agree that abuse of process, upon reaching a certain magnitude, may compel this court to dismiss the claim. As Ukraine stayed silent on the substance of Russia's statement, I have nothing to rebut. Instead, I will use this time to demonstrate how the representations of Ukraine and of the esteemed interveners contributed to Russia's abuse of process objection. It is undisputed that a claim once filed with the court must be precise and carefully tailored. The applicant may not appear before the court with a fragmented set of factual and legal allegations and demand to put these pieces together. Yet, the second day of hearings have left us with nothing but a variety of these puzzles, sometimes so contradictory that one may start wondering whether they even come from the same set. Ukraine attempts to give the court as much room for interpretation of its claims as possible. Certainly, in some fora, this whatever works tactics might be permissible. But it should not be so before this esteemed court. Here, it should be recognized and treated as abuse. Example. When discussing existence of dispute between the parties under the Convention, Professor Koh claimed that, I quote, that broader group of disputes would include, for example, the questions relating to responsibility for genocide here. Is Ukraine, as Russia alleges, really responsible for committing genocide? Or is it Russia that violates its duties under the Convention by falsely alleging that Ukraine is committing genocide, end of quote. For this, one may conclude that there is probably a number of disputes, a broader group. But this impression is wrong, according to Mr. Zions, who asserted that the subject matter of this dispute is, and always has been, the same: Russia's reliance on the allegations of genocide to justify harming Ukraine. Quotation ends. Voila, a single dispute, without any indication whose responsibility it pertains to. Second example. Ukraine claims that Russia violated Article 4 of the Convention. However, it fails to clarify which actions fall within the scope of this provision. Professor Koh states that Ukraine further claims that Russia violated Article 4 by invading Ukraine to punish a genocide based on the false allegations that Ukraine's officials are persons committing genocides for the purposes of Article 4, end of quotation. Accordingly, it appears that Ukraine's case on Article 4 relates to Russia's accusations against Ukraine's officials. But Mr. Zients steps away from this understanding and broadens the scope of Ukraine's allegations under Article 4. Ukraine claims that Russia improperly sought to punish Ukraine and its officials as persons committing genocide. End of quote. Now, it is unclear whether Ukraine considers that an action against the state, and not only against its officials, may also be qualified as punishment for genocide under Article 4 of the Convention. Well, third example. Ukraine intentionally keeps it unclear whether the alleged dispute between the parties relates to responsibility of Russia or responsibility of Ukraine under the Convention. During the oral arguments, Ukraine's position appears to have drifted to a statement that Russia violated Article 1 of the Convention by acting on the false allegation that Ukraine committed the international crime of genocide, which Russia became obliged to prevent and punish. End of quotation. That's not how the matter is perceived by, for example, the intervening states. Germany stated, I quote, "When the case was brought, Ukraine and Russia undoubtedly held diametrically opposing views as to whether or not Ukraine was responsible for the acts of genocide on its territory." Right after Germany, Australia took the floor and failed to ascertain the limits of the alleged dispute. The point of present importance is that the competing claims reveal a dispute about at least the application or fulfillment of Article 1 and 4 of the Convention with respect to Ukraine's alleged conduct. End of quotation. So, is it Russia or is it Ukraine's liability we are looking into? The further we go, the more confusing Ukraine's position gets. And I submit that this is done on purpose. But making controversial statements is one way of puzzling the court. The other way is evading a definitive statement where this is essential. For example, Ukraine does not say whether use of force is allowed by the Convention. In his presentation last week, Professor Tuvenin stated that Ukraine certainly does not contend that the Genocide Convention prohibits the unilateral use of armed force by one state against the other. Just a couple of minutes later, he added that Ukraine is not arguing that Article 1 of the Convention confers a right to use force. This is an elaborate way to say that the claimant simply has no position on the matter, which is essential for its claim. Whatever works. Finally, Ukraine fails to demonstrate consistency and floods the court with a spawn of ideas on what is allegedly the legal basis of Russia's responsibility. Is Russia responsible because of violation of obligation or abuse of right under the Convention? At paragraph 73 of its memorial, Ukraine accused Russia of abusing an undertaking. 3 paragraphs later, of abusing a right. Or perhaps the legal basis for responsibility is Russia's misuse of the treaty's provisions. Or is it their misapplication? Does Russia misuse its duties or undertakings under the Convention? Or, as Ukraine claims in paragraph 92 of the memorial, misapplies them? Or is it abuse of the entire Convention or misuse of it or misapplication, whatever of those terms might mean? We still have no answer to these questions as Ukraine, in words of its counsel, is adjusting its case. Perhaps a constructor for Ukraine's position would look something like the table you can see on your screen. Well, and this well echoes with what Russia argued last week. Ukraine has been elusive and inconsistent from the start. Inadmissible new claims were introduced by Ukraine in its memorial. They invoked new provisions of the Convention to which Ukraine failed to refer in its application. But again, this issue has already been dealt with last Monday. So was the matter relating to fabrication of evidence. That is a statement of Ukraine's Ministry of Foreign Affairs in which it allegedly opposed Russia's statements. The one that was published just a couple of hours before the filing of the application. Russia has already explained that the dispute already existed by then. Such evidence would not be necessary. Ukraine now attempts to stress that the publication was made, and I quote, before filing its application with the court, although it is clear that the 3-hour difference makes this filing virtually simultaneous. Finally, Ukraine argues that the intervention complaint has already been permitted by the court by virtue of the order dated 5th June 2023. This argument misses the point. What the court decided is that Article 63 of the statute is drafted in a manner that does not give it much leeway in dismissing the declarations of intervention. The court did not rule on whether Ukraine's puppeteering the matter in which the interveners were plotted, rallied, and executed is an abuse. Neither Ukraine nor the interveners have rebutted that interveners got engaged in this case upon Ukraine's direct request. The court does not have any alternative than to proceed on the basis that these states acted in collaboration with Ukraine from the very beginning. But it is not only the abusive process, not the only abusive process committed by the interveners. The court's order on the permitted scope of the intervention was disregarded. Several states, including Germany and Australia, which I have already cited, as well as, for example, Portugal, dwelled upon the issue of existence of dispute, something nobody authorized them to do. Other states impermissibly devoted their speeches to substantive issues unrelated to jurisdiction. Australia, Lithuania, the United Kingdom, and others addressed the Convention's purported obligation to assess the risk of genocide with due diligence before taking actions to prevent genocide. Plenty of states discussed states' obligation to apply the Convention in good faith. Some of the interveners, such as Canada and the Netherlands, even raised the issue of Russia's compliance with the provisional measures, which is a substantive issue that has nothing to do with the court's jurisdiction ratione materia. Now, and remarkably, New Zealand's oral presentation was devoted solely to the provisional measures order. Some states, such as Latvia, even assumed the role of co-applicants, continuously supporting the position of Ukraine's counsel and referring to Russia's many arguments as something that, I quote, must fail. Many intervening states, including Germany, Australia, Canada, the Netherlands, Poland, Lithuania, and others, used the court as a tribune for political pronouncements. Perhaps most illustrative in this regard is Lithuania's condemnation of the Soviet Union, which of course included both Ukraine and Russia. However, propagandistic statements have never been a permitted scope of interventions under Article 63 of the statute. Finally, as you may see, states whose positions were almost word for word identical decided to replicate them over and over again. This has been done in ignorance to the court's request for joint statements, which specifically tackled such scenario. What is even worse, we have seen no indications that the interveners wanted to interpret the Convention. They proclaimed that they want to seize the opportunity. They stressed the fundamental importance of interpretation. However, none of them has intervened in any of the past 15 cases that were brought under the Convention in this court. None intervened for 4 years while this court has been considering the Gambia versus Myanmar case. As you know, the matter is still pending. A lot of the states who intervened in this case had a chance to present their views on the interpretation of the conventions in the legality of the use of force cases where claims were filed against them. However, then, they did not seem as interested in the convention or its proper interpretation. Instead, they challenged the court's jurisdiction. The representative of the UK went as far last week as to say that, I quote, "It is unthinkable that a state fulfilling its undertaking to prevent genocide in good faith could do so through aggression." These words would have been very appropriate in the legality of the use of force cases. Do not get misled. In the present matter, the intervener's intent is purely instrumental. Madam President, members of the court, Russia has shown that each procedural step of the Ukraine bears a stigma of manipulation of the proceedings. From the preparation to file this application and until the present oral hearings, Ukraine has acted and continues to act abusively. There could be no greater evidence, no more exceptional circumstances to uphold the abuse of process objection. I now move to my final submission and address Ukraine's statement related to the alleged violation of the court's provisional measures order. There is no reason not to keep it brief. You have heard counsel for Ukraine asserting that Russia has no respect for the court, that it defies and challenges the court as an institution. However, we are here precisely because Russia holds this court in high regard and relies on international law. Unlike Ukraine, Russia does not invent any new concepts or unprecedented arguments. To the contrary, what it requires is that the court upholds its established jurisprudence. And this concerns not only the application of the legality of the use of force cases. This approach is just as fair for Ukraine's arguments regarding the court's provisional measures order. Such established jurisprudence is straightforward. There is no place for deliberating over compliance with orders for provisional measures at the jurisdictional stage of the proceedings. Russia did not focus on such allegations earlier precisely because the present phase of the case has nothing to do with them. An inquiry into whether provisional measures were violated requires factual determinations. As Judge Yusuf emphasized in Qatar versus UAE, issues of fact are normally a matter for the merits. In that case, Qatar accused the UAE of violating the court's provisional measures order both in its memorial and at the preliminary objection stage. Qatar developed a long argument which resembles the one advanced by Ukraine now. The court, however, did not address this claim in its 2021 judgment, where it rejected jurisdiction over the matter. There is no reason for Ukraine not to be aware of such approach. In fact, it is the second time Ukraine attempts to escalate this issue while the case is at its preliminary objection stage. In the 2019 judgment, in the ICSFT third case, the court indicated that issues of compliance with the provisional measures order, I quote, may need to be addressed by the court at the later juncture, should the case proceed on the merits. This 2019 judgment on Russia's preliminary objections contained no determination whatsoever concerning Ukraine's allegations. Madam President, members of the court, the same approach has been followed by you in the Treaty of Amity case, which is still pending. The 2021 judgment on preliminary objections records that the court, and here I quote once again, considered that any issues relating to the implementation of the provisional measures may be addressed at the later stage if the case proceeds to the merits. The approach is no different if the case concerns the Genocide Convention. In Gambia versus Myanmar, Gambia too argued that Myanmar has failed to comply with the court's provisional measures order. The court again did not address this matter in any way in its 2022 judgment on preliminary objections. All this leaves no doubt that Ukraine's arguments on the alleged violation of the provisional measures order are misplaced, at the very least. There is one further point raised by Mr. Gimblett that I must address. He argued that a court can exercise jurisdiction over provisional measures even if there was no jurisdiction in the original case. Reference was made to the request for interpretation of the Avena judgment case. However, as you may see on the slide, what the court really stated is that if the jurisdictional basis in the original case has lapsed, the court may still interpret its own judgment under Article 60. The verb lapsed was used for a reason. It presupposes that something has existed in the first place. Therefore, jurisdiction in the original case is still a must. Unless the court finds jurisdiction over the present claim, the court's order in the aforementioned case is of no avail to Ukraine's position. Madam President, this concludes my presentation. I thank you for your attention, and unless you find it appropriate to have a coffee break, I kindly request that you call Maître Jean-Charles Chikaya to the podium.
I thank Mr. Dovichenko. Before I invite the next speaker to take the floor, the court will observe a coffee break of 10 minutes. The sitting is adjourned. Please be seated. The sitting is resumed, and I shall now give the floor to Mr. Jean-Charles Chikaya. You have the floor, sir.
Merci, Madame la Présidente.
Thank you, Madam President. Madam President, distinguished members of the Court. It is a considerable honour for me to speak before the Court and to do so in the name of the Russian Federation. My task is to present the Russian Federation's arguments in response to the observations made by the intervening states on the second preliminary objection. Ukraine's and the interveners' aim is to convince the Court that under Article 9 of the Genocide Convention, it has jurisdiction to rule on the lawfulness of the special military operation and the recognition of the DPR and the LPR pursuant to the Charter of the United Nations and customary international law. Indeed, the 32 intervening states, of which 23 are NATO members and 23 are member states of the European Union, all appeared to suffer from a parroting disease, mechanically repeating the same argument on the purported broad nature of Article 9 of the Convention at issue. Yet, Article 9 does not grant the Court jurisdiction in regard to jus ad bellum. To attempt, as the other side has done, to fit the facts of this case to the Procrustean bed of the compromissory clause is both artificial and vain. The interveners have repeated incessantly that their construction of Article 9 is broad. Yet they should know full well that their contention is inconsistent with the way the Court has defined its jurisdiction versione materia in the past. The interveners have focused on Ukraine's claims regarding the use of force. They have said nothing about the issue of the recognition of the DPR and the LPR. It would appear that Ukraine's attempt to transform the object of the Genocide Convention has become all too obvious. The key to Russia's second preliminary objection has been entirely ignored. Pursuant to Article 9, the Court may only entertain disputes relating to breaches of the Convention itself. It lacks jurisdiction with respect to alleged violations of other rules of international law. Many interveners have argued that the Court has jurisdiction to determine if the Convention authorises the use of force, yet neither of the parties in the instant case has claimed that the Convention permits the use of force. In other words, this question is devoid of relevance. The real question is whether the Court has jurisdiction to make a determination on the lawfulness of actions which, according to Ukraine, were undertaken to prevent or punish genocide pursuant to rules of international law other than the Convention itself. Herein lies the disagreement between the parties. Russia's view is that the Court's jurisdiction ratione materia under Article 9 does not cover such issues. Might I immediately emphasize an aspect of juridical policy of the utmost importance? A broad construction of the compromissory clause, as the interveners would have it, would considerably broaden the substantive scope of the Convention. It would allow all sorts of states to refer other states to the court by relying on the compromissory clause. For instance, Serbia could bring an action against the NATO member states who used force in 1999 with the stated aim of preventing genocide. States accused of genocide, such as Myanmar, might seize the court to challenge the lawfulness of the unilateral sanctions imposed upon it. States, as Mr. Alfredo said this morning, states whose national courts have launched criminal proceedings for acts of genocide in accordance with universal jurisdiction might be brought before this court for alleged violations of customary international law rules on the jurisdictional immunity of high-ranking officials of the state. Can one reasonably consider that the 1948 Convention has such a broad normative scope? Would the intervening states themselves accept that such an extensive projection of this Convention and of its compromissory clause is part of substantive international law? I doubt it, as indeed was made known by NATO member states in cases concerning the use of force. I do not doubt that the court will not be swayed by such an interpretation of the Convention. Let me move on to the correct interpretation of Article 9 of the Convention. Madam President, let us look at the interveners' construction of Article 9 of the Convention. Their view is that Article 9 is a one-of-a-kind compromissory clause which confers upon the court greater jurisdiction than do other provisions on the settlement of disputes. Firstly, we need to determine the actual meaning of the word fulfillment in Article 9. The interveners have laid great store by this issue. But this term adds nothing to the term application. The ordinary meaning of the word fulfillment is the application of a rule in accordance with its provisions. The court has the power under all compromissory clauses to determine whether an obligation has been performed, even if the word fulfillment is not actually used. Thus, Article 9 does not confer broader jurisdiction upon the court simply because it contains the term fulfillment. The court has stated more than once that it does not have the power to rule on international law breaches other than those which arise from the Convention itself. Thus, in its 2007 judgment, the court indicated clearly that the term fulfillment is not relevant to the establishment of its jurisdiction. This ought to be the end of it. Secondly, some interveners have referred to the effet utile principle, claiming it should lead to giving a separate effect to the word fulfillment. But the effet utile principle cannot be invoked when there is no discernible distinct meaning to be given to a particular term, or when the travaux préparatoires of the treaty drafting give no indication of any such intention. The court stated in an earlier case that it can happen that parties to a treaty adopt a provision aimed at dissipating any doubt, even if such a provision is not strictly necessary. Considerable caution must be exercised when the effet utile principle is invoked to extend considerably the court's jurisdiction. And finally, why should the effet utile require that a meaning be given to the word fulfillment, which would go beyond the Convention? What is it that has to be applied or fulfilled? Rights and obligations contained in the Convention, nothing else. Even if one were to insist on the effet utile, one could not go beyond the scope of the Convention. Thirdly, the interveners have argued that the object and purpose of the Convention should lead to a broad interpretation of Article 9. They have relied extensively, broadly, if I may say, on a passage in the 1951 Reserve's consultative opinion. The only real question is whether the object and purpose can be used to broaden the scope of the court's jurisdiction pursuant to Article 9. The answer is no, they cannot. The court has been quite clear on this point. The fact that certain rules are particularly important and have an erga omnes or jus cogens character is not sufficient to confer upon the court jurisdiction to entertain a case. This view was confirmed in the Croatia genocide case. The court has also ruled that the text of the convention clearly indicates that jurisdiction under Article 9 is restricted to disputes relating to the interpretation, application, or implementation of the convention, no less, but also no more. As to the travaux préparatoires for the drafting of Article 9, there is one certainty. The drafters did not intend to extend the court's jurisdiction to cover disputes which fall outside the convention's provisions. That goes without saying. In the Bosnian genocide case, Judge Tomke quite rightly observed that the travaux préparatoires did not add anything juridically relevant, and that the inclusion of the expression fulfillment of the present convention to the compromissory clause added nothing to the substantive obligations of the parties to the convention, and flows from the notion of application of the convention for interpreting the term fulfillment, and the travaux préparatoires did not broaden the court's jurisdiction ratione materia. Judge Oda also observed that, and I quote, there was a certain amount of confusion among the drafters of the convention, namely due to the unique nature of their task and in view of the state of mind that prevailed at the time. Ukraine's and the interveners' position that the travaux préparatoires support a broad interpretation of this provision must therefore be rejected.
Fourthly, the interveners also relied on two authors. They do not mention other authors who openly contradict that position, such as Judge Greenwood, but even the two authors that were mentioned do not support their viewpoint. No meaning is provided to the word fulfillment, says one author. The other author says that the word fulfillment doesn't add anything decisive to the text. It could mean, at best, an application that meets the requirements of the standards. The word fulfillment is not significant for the determination of the court's jurisdiction, as the court itself confirmed in the Bosnian genocide case. And he concludes that Article 9 does not cover only covers disputes under the convention, but disputes relating to other rules of international law, even when they relate to allegations of genocide. In sum, neither the convention's text nor the travaux préparatoires support the interpretation of Article 9 suggested by the intervening parties. Even the court's jurisprudence runs counter to this interpretation, as does its doctrine. Fifthly, some interveners, such as Greece, contended that the important role of the court under Article 9 of the Convention would require a broader interpretation. Once again, they referred to the separate opinion in the Congo versus Rwanda case, in which 5 judges who indicated that the court, and I quote, has an important role to play under the Genocide Convention, unquote. Nobody denies that the court plays an important role in the settlement of disputes, of all disputes, but this important role cannot take precedence over the principle of consent. This appears clearly in the court's decision in the present case. In that case, France's position as a state intervening of Article 9 warrants more attention. France contended that, indeed, that the French version of the text is to be taken into consideration because the expression relating to genocide is broad enough to include both its commission and its non-commission. Moreover, the term including suggests that other dispute categories can fall within the scope of Article 9. End of quote. However, in its preliminary objections filed on the 4th of July 2000, In the lawfulness of the use of force case, Bosnia and Herzegovina versus France, France had argued that Article 9 of the Genocide Convention could not be relied on to establish the court's jurisdiction. At the time, France contended by applying very rigorous legal logic that, and I quote, by claiming to rely on this convention to establish that the court has jurisdiction in the present case, the Federal Republic of Yugoslavia is instrumentalizing the 1948 Convention and its compromissory clause and is breaching the principle of good faith. And that it is using this convention to take France to court, even though these accusations are essentially based on alleged breaches of the United Nations Charter and on breaches of certain principles and rules of applicable international human law applied to armed conflicts that cannot in themselves establish that the court has jurisdiction. End of quote. Well, we have to admit that it is very surprising for the country where Descartes was born to contradict itself to such an extent. O tempora, O mores, O the times, O the customs. Finally, some interveners contended that Article 9 requires a broad interpretation because it does not impose any precondition to the seizing of the court. However, it is the preconditions for the season of the court, such as negotiations, that have no bearing on the scope ratione materia of the court's jurisdiction under the compromissory clause. So this is common knowledge. I would now like to address my second point, which is the obligation to act within the limits of international law. Does the Convention encompass an obligation to act within the limits of international law, as Ukraine suggests? If indeed this is the reading of the Convention, then one would also include other rules of international law into the Convention. Virtually all the interveners repeated, just like Sweden, that a state cannot claim to apply international law by violating international law. Germany went a step further and declared that Article 9 applies to conflicts relating to an unlawful action, but which is justified to prevent and punish genocide. However, this question is not included in the scope of the 1948 Convention. Everything that is more or less connected to genocide, or supposedly so, is not automatically included in the scope of the Convention. The UK seemed to suggest that Article 1 of the Convention does not include the obligation to act within the limits of international law, but only within some of the rules of international law, in particular the UN Charter. It is unclear where this distinction comes from. The Convention does not contain any provision that would include United Nations law in its material scope. And even when the UN organs are mentioned, for instance in Article 8, no obligation is specified as to the obligations. Therefore, no dispute can arise on this issue under the Convention. Some interveners added that Article 9 gives effect to the parties' pre-existing obligations under the UN Charter for peaceful settlement of disputes. However, one cannot conclude from this that the Convention includes other rules of international law. One can say that all compromissory clauses give effect to the principle of peaceful dispute settlement. But this has no bearing on the court's jurisdiction ratione materiae under these clauses. Otherwise, compromissory clauses would have the same scope as voluntary declarations of mandatory jurisdiction devoid of any reservations. Some interveners referred to the oil platforms cases. The court had noted that questions relating to the use of force are not in themselves excluded from the scope of application of the 1955 treaty. This case, however, is not relevant to the claims that Ukraine has made in the present proceedings. The oil platforms case focused on Article 20, paragraph 1D of the 1955 Treaty of Amity between Iran and the US. This provision allowed for specific defense pertaining to the issue of the use of force. The key point in this case is as follows. The court was able to examine the question of the use of force and self-defense because Article 20 of the 1955 Convention authorized it or even obliged it to do so. The same does not hold true for the 1948 Convention. Furthermore, Ukraine isn't simply asking the court to interpret the convention in the light of other rules of international law. Ukraine wishes the court to use its jurisdiction to decide whether Russia has violated the rules of international law other than those in the convention itself, and Ukraine wishes that the court should draw all the legal consequences from this exercise. The interveners also referred to the military and paramilitary activities case, and in particular to the court's statement according to which the use of force is not the appropriate method to supervise and ensure respect of human rights. However, this recital is not relevant to the present case. Yet again, the applicable treaty was the Treaty of Amity, containing a provision similar to the one that I just mentioned in the Iran versus USA case. Cyprus's position was rather odd. Cyprus suggested that an obligation to act within the limits of international law would exist based on an analogy with countermeasures. According to Cyprus, Article 1 of the Convention constitutes a form of countermeasure in the face of genocide, and as a consequence, measures taken based on Article 1 should comply with international law. This argument can be refuted very easily. Indeed, Article 1 does contain a primary obligation, but it does not incorporate law on countermeasures or the law on international responsibility into the Convention. Moreover, as the court held, the obligation to prevent applies even if genocide has not been committed yet. Of course, Ukraine will continue to argue that its claim is based on a breach of Article 1 and 4 of the Convention and not of other rules of international law, but that only makes sense if we accept that Article 1 and 4 include other rules via the implicit obligation to act within the limits of international law. I think that we have sufficiently demonstrated that such an obligation cannot reasonably be found in this convention. Some interveners relied on Article 31, paragraph 3c of the Vienna Convention on the Law of Treaties. Bulgaria, for example, suggested that by using the provisions of Article 9 would provide the court with jurisdiction on compliance with acts carried out by a contracting party within the framework of the legal system in its entirety. This interpretation confuses systemic interpretation with the question of limits to the court's jurisdiction by virtue of the compromissory clause. Article 3, paragraph 3c of the Vienna Convention on the Law of Treaties cannot be relied on to extend the court's jurisdiction ratione materia. Other interveners, such as Austria, emphasize that it is not necessary to establish whether Russia's conduct is relevant under other rules of international law. In the present case, what matters is that the court has jurisdiction to rule on whether Russia's conduct is compatible with the Genocide Convention. However, the interveners did not address the key issue, that is, does the Convention govern the rule of force and the recognition of states or not? The obvious answer is no. The court cannot ascertain the lawfulness of Russia's conduct under the UN Charter and under customary international law, because by doing so, it would overstep the material scope of the applicable convention and the principle of consent.
Let me address the third part of my presentation now, Madam President. Some rather remarkable propositions were made to this effect. On the issue of the prohibition of identified allegations, some interveners argue that rather than make abusive allegations of genocide without having performed its due diligence obligations, the state may seize the competent bodies of the United Nations. But seizing the United Nations on a genocide issue would necessarily require an allegation of genocide or of threat of genocide. This argument goes round in rings. There has to be an allegation. That is inevitable. The idea that states must provide substantive or conclusive evidence of a genocide or threat of genocide prior to or at the time of making an allegation is equally unconvincing. As observed Judge Bennouna, and I quote, "The genocide concept has been overused, utilized left, right and center by propagandists of every ilk, and that, and I quote again, in none of its provisions does the Convention cover genocide allegations or the use of force based on such allegations," end of quote. Allegations of genocide are frequent among states, and more often than not without the slightest evidence. It would be unreasonable, therefore, to consider that the court might be seized for each of these past or future allegations unless the state in question is able to provide conclusive evidence of genocide or threat of genocide. This distinction does not in the least appear in international practice, as I've said. To conclude, a simple genocide allegation, be it abusive, true, or mistaken, does not constitute in itself a breach of the Convention. Russia and Ukraine appear to agree on this point, at least at this juncture of the proceedings. The interveners are not in a position to pinpoint a right provided by the Convention which might have been subject to an abuse. I shall be a little more brief on this, Madam President. Ukraine... This argument by Ukraine has a major failing. Ukraine cannot pinpoint a right under the Convention which might have been subjected by Russia to an abuse of rights. In particular, the Convention does not cover the use of force or the recognition of states. If there is no applicable law, there is no possibility of abuse of this non-existent right. This is a matter of logic and should encourage you to reject Ukraine's claim on this issue, that of the abuse of rights. The court must determine the exact scope of Articles 1 and 4 of the Convention, in other words, if they govern the use of force or the recognition of states. And since they do not, these actions do not fall within the scope of the Convention. Thus, the Convention must not be used abusively or in bad faith in this respect. In the last part of my presentation, I would like to point to, and this was done a moment ago, to what I would call the violation by the interveners of the court's order, authorizing them to intervene. With blatant disregard for the court statute, the rules of the court, and the court order dated 5th of June 2023, the interveners persist in broaching issues that they have no right to comment upon. The merits of the case, the existence of a dispute between parties, the admissibility of the application, and the application of the Convention in this case. A couple of examples. In the almost identical written observations, Belgium, Croatia, Denmark, Estonia, Finland, Ireland, and Luxembourg and Sweden all brought up the issue of the use of force and its link to Article 1 of the Genocide Convention and the due diligence obligations of a state under that same article. These are issues which clearly bear no relevance whatever to this stage of the proceedings, since they belong to the merits, assuming the merit stage is ever reached, of course. Ireland has gone one step further by simply ignoring the court's order. Ireland has provided the court with its own interpretation of Ukraine's submissions. Basically, Ireland has not interpreted the provisions of the Genocide Convention, but has tried to help Ukraine by attempting to correct Ukraine's clearly defective conclusions and has requested that the court rule on the merits in a given way. Throughout the hearings, the interveners, such as Germany, openly talked about the existence of a dispute. For example, German said, "Suffice it to be noted that when the case was brought before the court, Ukraine and Russia had undoubtedly diametrically opposed views as to whether Ukraine was or not responsible for acts of genocide committed in its territory. Germany, and I continue to quote, therefore considers that there is a dispute under Article 9 of the Convention. The interveners also improperly raised the issue of the application of the Convention in the instant case with regard to jurisdiction. Germany, yet again, said, and I quote, the question before the court today is solely to determine if it has jurisdiction to examine this case. Germany is firmly convinced that it does. Australia. I quote, the first point is that a dispute regarding the scope, content and performance of obligations arising from Article 1 and 4 of the Genocide Convention falls within Article 9. More specifically, a dispute regarding the scope or content of these articles concerns, by definition, the construction of the Convention, whereas a dispute regarding the performance of obligations arising or supposedly arising from these articles pertain to the application or performance of the Convention. In this case, and that is the agent actually speaking, Article 9 is engaged on both issues. Greece. In its first part, Greece said the word concerning requires only that the subject matter of the dispute is alleged breaches of the Convention. Thus, when, as in the instant case, an application concerns the consistency of certain actions with the Convention, the court may exercise its jurisdiction under Article 9, distinctly from the issue of whether this conduct is also in breach of other rules of international law, and the question as to whether the court has jurisdiction to entertain these matters. All these questions go clearly beyond a simple interpretation of Article 9 or the scope, ratione, materia of the Genocide Convention. They relate to the merits of the case. The interveners were not even at pains to disguise their abusive conduct and their actual purpose in joining these proceedings as interveners. And here, the idea was indeed to help Ukraine, whereas one might have expected from the interveners to shed some additional light on international law, in particular the question of construction, which the court is examining today. New Zealand declared that there is a dispute between the two countries and Article 9 of the Convention, and Ukraine rightly submitted this dispute to the court. New Zealand has felt at liberty, it seems, to characterise Russia's preliminary objections as, and I quote, significant false declarations. New Zealand repeated this view during the oral proceedings. Its agent even went as far as to say, and I quote, I do not intend to repeat all our points made in our written observations. I shall not either repeat the points made by Ukraine and other intervening states. We simply broadly support the points they made, end of quotation. Portugal, rather than providing the court with an actual interpretation of Article 63 of the Genocide Convention, has even made observations as if it were co-applicant. Portugal argued that application concerns existing dispute, B, the dispute concerns implementation and application formation of the Convention, C, the dispute concerns the substantive obligations which arise from the Convention, D, the application was appropriately filed by one of the parties to the dispute. Further on, Portugal made a conclusive declaration stating that a dispute under Article 9 of the Convention clearly exists between Ukraine and the Russian Federation. Portugal persisted during the hearings and said the Portuguese Republic is of the opinion that the dispute in question relates to substantive obligations under or connected to the Convention. End of quotation. And finally, Lithuania. No comment, I would say. Lithuania defends the respect of the territorial integrity of another state. That is Lithuania speaking, and opposes the defendant's disregard for international law by giving false pretexts based on the Genocide Convention that form the gist of this case. End of quotation. This is how these interveners have perverted Article 63 of the statute, which might have brought them, if that was their purpose indeed, to shed further light on what all the states parties must consider to be the law with regard to these provisions. Before closing, Madam President, may I briefly recall my main submission. The 1948 Convention, as can be seen from its provisions, governs nothing but genocide. It does not extend to actions or conduct governed by other rules of international law, including the Charter of the United Nations. The Court's jurisdiction under Article 9 of the Convention is restricted to alleged breaches of the Convention itself. Madam President, distinguished members of the Court, this concludes my presentation. May I thank the Court for its kind attention. And Madam President, may I ask you to invite the agent of the Russian Federation, His Excellency Ambassador Alexander Shutkin, to take the floor for the final submissions of the Russian Federation.
I thank Mr. Chikaya, and I now invite His Excellency Mr. Alexander Shulgin, agent of the Russian Federation, to address the Court. You have the floor, Excellency.
Madam President, distinguished members of the Court, I have the honor to conclude the presentation of the Russian Federation's arguments and to announce our final submissions. The Russian Federation's agents and counsels have consistently and comprehensively explained why Ukraine's claims in this case cannot go beyond the preliminary objections stage and why they are doomed to fail. Indeed, any other decision by the Court other than this one would allow states not to rely on their real rights and obligations under the treaty, but to instrumentalize all sorts of foreign concepts such as misuse, abuse, and this would pave the way for frivolous proceedings on all sorts of matters. This would upset the system of compromissory clauses and would enable states to circumvent very easily the principle of consent of states to the court's jurisdiction. What is even more dangerous is that in an attempt to invent an allegation of abuse of rights against Russia, Ukraine alleges the existence of a discretionary power, into inverted commas, under the Genocide Convention to, and I quote, act to the detriment of other states, end of quote. That could even include the use of force. It goes without saying that the Court cannot rely on such an assumption. Ukraine and its 32 partisans did not change the fact that Ukraine's claim does not rely on the Genocide Convention, and that when Ukraine seized the court, no dispute between the parties existed on the claims submitted to the court by Ukraine. Its lawyers are now forced to look for posts on the internet to support the contrary by insisting on the fact that Russians supposedly used the convention as a legal basis, notwithstanding the obvious fact that the Russian Federation has relied on the UN Charter for its actions. The intervening states, in a blatant display of duplicity, have attempted to pervert the functioning of the compromissory clause of the Genocide Convention by brazenly making a turnaround on their previous positions before this very court when NATO bombarded Yugoslavia under the pretext of preventing genocide in Kosovo without making any reference to the United Nations Charter. The intervention of the 32 states who simply repeated Ukraine's position shows that Ukraine does not have faith in its own legal arguments and is in fact counting on this unprecedented attempt at exercising collective pressure on the court. This attempt must fail. I will now recall the 6 preliminary objections that the Russian Federation has submitted to the court. First, no dispute existed between the parties because Ukraine has never made the Russian Federation aware of its claims before filing its application, and therefore the Russian Federation was not aware of a dispute with Ukraine before this critical date. Secondly, Ukraine's claims do not fall manifestly under the court's jurisdiction ratione materiae under Article 9 of the Convention, in particular because these claims do not involve breaches of obligations under that convention. Thirdly, the new claims submitted by Ukraine in its memorial are inadmissible and largely demonstrate that Ukraine itself did not know on what grounds it was really making its claims at the time of initiating proceedings. Fourthly, the court's potential judgment would be devoid of any effet utile because a judgment delivered under the Convention cannot affect the rights and obligations of states under the United Nations Charter and under customary international law. And it is these instruments that Russia has relied on for its actions. Fifthly, Ukraine's claim based on reverse compliance is inadmissible given that states are not allowed to request preventive judgments that protect them from the establishment of possible breaches. Sixthly, and finally, Ukraine's case constitutes an abuse of process for a host of different reasons that our councils have enumerated. Madam President, what matters is that the court confirms its own jurisprudence, that is to say, that the use of force and the recognition of states are not within the scope of the Convention. Before moving to the final submissions of the Russian Federation, I would like to express our gratitude to the court's registrar and his staff for their precious assistance, and I would also like to thank the interpreters for their excellent hard work and their devotion. We would like to thank all the members of the court for paying attention to Russia's arguments. Madam President, I now have the honor to read Russia's final submissions. And I quote, "Having regard to the arguments presented by the Russian Federation in its preliminary objections and during the hearings, the Russian Federation respectfully requests the court to adjudge and declare that the court lacks jurisdiction to entertain the claims made by Ukraine against the Russian Federation in the present proceedings and or that Ukraine's claims are inadmissible. End of quote. This concludes the Russian Federation's final submissions. I thank you for your kind attention.
I thank the agent of the Russian Federation, whose statement brings to an end this afternoon's session. The court takes note of the final submissions which you've just read out on behalf of your government. The court will meet again on Wednesday, 27 September 2023 at 3 p.m. to hear the second round of oral argument of Ukraine. At the end of that sitting, Ukraine will present its final submissions. The sitting is adjourned.